Okay. Miss Bass is not going to be away anymore. She was District 5. John Taylor is the new representative for District 5. Yeah.
Is Susan here? She was dry here.
How you doing there, son? Good to see you.
I'm Rain. How are you? I'm with Hitchcock. Central Incorporated. I want to see you first.
Horace.
That's what I thought. Like horse name.
Yes,
Okay.
yes. Horace John.
That's what I got.
Yes.
That's what I thought I heard. Just want to make sure.
Absolutely.
Okay.
If you got blue forms, bring them up here. We can take them.
Let me know when you're ready to kick off.
How you doing?
nothing to say.
So, no, I'm talking about. Yeah, it's probably October. Okay. All right.
Is she gonna stay?
Ready?
Ready.
Stand by for one.
Okay, how many problems and pain and vision you cause on how many people you got vision in it?
Okay. Miss Rachel? Miss Rachel, we ready? Okay. Good morning. Good morning, everyone. We're glad to have all of you out today. We appreciate your attendance for this meeting. Just one housekeeping matter before we really get into the meeting, of course. Could everyone either put your phone, turn it off, or put it on silent? We've got quite a few people here, and it's really helpful to the proceedings. So the board would appreciate you doing that. And other than that, I'll say good morning and welcome. The meeting of the Escambia County Board of Adjustment for August the 21st, 2024 is hereby called to order with 5 members present, and we do have a quorum for all our hearings. Will the clerk please swear in the members of the staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of the staff's resumes have previously been provided and remain on file, of course, for reference. The board has previously recognized the staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for August 21, 2024, with the Development Services staff's findings of fact, has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence.
Motion.
I have a motion. Do I have a second? Second. I have a second. All those in favor of this motion, please raise your right hand. Let the record reflect this motion passed unanimously. Madam Clerk, do we have a proof of publication?
Yes, sir.
Did the publication meet all the necessary legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the readings of the legal advertisement. Do I hear a motion?
Motion.
I have a motion. Do I hear a second? Second. I have a second. All those in favor of this motion, please raise your right hand. Let the record reflect that this motion passed unanimously. Members of the board, have you reviewed the minutes for the Board of Adjustment meeting held on July 17, 2024? Upon your review of the minutes, are there any additions, deletions, or corrections? Let the record reflect that no board member indicated as such. The chair will now entertain a motion regarding the minutes for the Board of Adjustment meeting held on July 17, 2024. Do I have a motion?
Motion.
I have a motion. Do I have a second? Second. I have a second. All those in favor of this motion will raise your right hand. Let the record reflect that this motion passed unanimously. We'll now turn to the purpose of the Board of Adjustment and the conduct of this meeting, and this explanation will perhaps help many of you, I'm sure, have not been here before, but it will give you an idea of how we will proceed.
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decisions may be set aside. The development order or permit may be revoked, or development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of board. Those forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record.
And also, I'd like to explain ex parte communications. All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commissioners Resolution 96-13 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe this communication. With that said now, we turn to our first case this morning. This is case number CU 2024-15, 810 Archer Road and 800 block Archer Road, a conditional use request to allow a restaurant not among the permitted uses requested by Gregory Campbell, agent for DKJ Real Properties, LLC, owner. First, board, let me ask you, has there been any ex parte communication in this case? Let the record reflect, no board member has indicated there was. Has there been any knowledge or information obtained from a site visit or other sources? Let the record reflect that none was indicated. Does any board member intend to refrain from voting due to a voting conflict of interest? And let the board, let the record reflect that no more board member indicated as such. Therefore, would the individuals who are a party to this item please come to the podium? We will ask you to state your name and address for the record so that you can be sworn in by the clerk.
Gregory Campbell, I'm the civil engineer. My address is 2120 Maria Circle.
Please raise your right
Mexico.
hand. Oh, please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. And you can move the microphone up.
Good morning, sir.
Good morning.
We're glad to have you with us.
Thank you.
Were you provided a copy of the criteria required to obtain a conditional use and a copy of the findings of fact as developed by our staff?
Yes, sir. I've read it and I agree with the findings and recommendations of the staff.
And you understand that all criteria must be met in order for the board to grant a conditional use.
Yes, sir.
We can approach this one of two ways. If you prefer, you might make an short opening statement, or if you prefer, the staff will make its findings, and then, of course, you will be able to follow up with any additional statements.
Yeah, I'd rather do the latter.
Okay. Andrew, I guess we're to you.
Excellent. Good morning, Board. Caleb McCarty, Planning Manager and AICP Certified Planner. Greg, you sit down. Our first map here shows the location. This is at the corner of Archer and Highway 29. Our next slide shows the 500-foot radius zoning map. The zoning of the property is commercial, as well as the surrounding property. And our future land use designation for the property is also commercial. This shows an aerial photograph of the map. And for our photos, we posted a notice of public hearing sign on Highway 29. And this is looking northeast, kind of catty-cornered at the corner there. There is a current temporary mobile vending unit on the site. This is looking north along South Highway 29 from the site. This is looking across Highway 29 from the subject property. And this is looking south along 29 there. We also put another hearing sign on Archer Road since this was a corner type of lot. And this is looking northeast along Archer Road. And this is looking southeast across Archer from the property. That concludes our photography and our maps. And if you like, we can somewhat expedite this unless we have some speakers on it, but staff did find that it met all the criteria for approval with the conditions that the development review process must be applied and approved from the county. And related to mobile vending units, the primary intent for restaurants not otherwise allowed is essentially a food truck court type of use, which is considered like an outdoor type of use in this zoning district, which triggers this hearing. We would just say that the DRC must be approved for site development and that the individual mobile vending units would attain permits from the county. But we do recommend approval for this case.
Does anyone have any questions for the staff on this? Mr. Campbell? I'm sorry. I'm old. Work with me.
I'm with you.
Would you just explain what you'd like to do?
You know, it's going to have just three food trucks. There's not going to be any bands or any entertainment that would disrupt any neighbors. Also, we have a 16-foot buffer next to the residential property, adjacent residential, that will have a fence and, you know, plants to buffer any noise from the food court. It's pretty straightforward. You know, we'll have to follow, of course, it's also going to have a bathroom for people that go to the food court. It'll have a septic tank system, also a retention pond on the corner. So it's.
Are there questions from the board members? I have a question. What hours are you planning?
I think it's going to be 7 p.m. Probably 7 a.m. to 7 p.m.
Okay, and you say that there won't be any outside entertainment?
Correct.
And it does back up on some neighborhoods there, or some homes there. And what is your buffering plan again?
We'll have a 16-foot wide landscape buffer and also a 6-foot high wooden fence along that property line that abuts to the residential.
Okay.
That buffer requirement, and just to interject, that buffer requirement is required by code, and the applicant realized that. So they would have to do that at the development review process, and we would confirm, compliance with that code requirement
Yeah.
at that time. He showed it on his preliminary site plan.
Yeah,
the buffer.
Well, you know, the current concern is, number one, is you've got a business backing up right against homes, and that often doesn't have very happy outcomes. But if I understand what you're saying, your hours will be from essentially 7 to 7. If that's true, and there's not going to be any outside entertainment pavilion or anything like that. With
No
band music.
No alcohol, no,
No, and you won't be serving alcohol.
no.
All right. Board members, do you have any questions for the applicant?
I have two questions. Will access be off of Archer or off of 29?
It'd be off Archer Road.
And is the property to be paved, hard paved or gravel?
The driveway coming in would be paved, but the rest would be gravel.
Any more questions from board members?
Mr. Chairman, I move that we accept staff's findings of fact and grant the request.
Second, Mr. Chairman.
We have a motion, and we also have a second, that this request petition be granted. Is there any further discussion by the board? Seeing none. And according to our blue slips here, we have no individuals that wish to speak on this in addition to Mr. Campbell. Given that fact, we've come to the point now we must make a decision. All those in favor of Mr. Smith's motion to grant the application as presented by the staff and Mr. Campbell, please raise your right hand. Let the record reflect that this petition was granted unanimously.
Thank you, sir.
Yes, sir. Thank you for coming. We now turn to our second case. This is 1030 Underwood Avenue, 1030 block Underwood Avenue, 1030 Underwood Avenue B, 80 Underwood Avenue, and 213 Douglas Avenue. The request is to allow an outdoor recreational facility. It's requested by Patrick Jewell, agent for Pensacola State College and Pensacola Junior College owners. And do we have the representative? Can you come forward, sir? And did I say your name right? Probably didn't.
You didn't, but nobody does. It's pronounced Yaley, like you're cheering for somebody named Lee. Yaley.
Well, bear with me.
No problem. It's been my whole life. You don't have to worry about it.
Please,
Well, sir, we're glad to have you with us. Please turn and face the clerk. Raise your right hand. Please give us your name and address for the record and be sworn in.
Sure. My name is Patrick Yaley with McKimmon Creed. Address is 1206 North Palafox, Pensacola, Florida 32501.
do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And before we get started, sir, I have to ask the board, are there any ex parte communications regarding this case? Let the record reflect there are none. Knowledge or information obtained from a site visit or other sources. Let the record reflect there are none. Is there any member who intends to refrain from voting due to a voting conflict of interest? Let the record reflect there are none. Would you like for the staff to make its presentation? Or would you prefer to make an opening statement and follow up? It's entirely up to you.
I'll allow staff to present and then
All right.
speak.
Okay, could we have staff? And on this one, I'd appreciate that we go through the findings.
Excellent. All right, thank you again, Board. Here, we have the location of the property. This is off of Underwood, south of Douglas, and runs along Tippin, quite close to the airport. This is our 500-foot radius zoning map, showing that the zoning is commercial. And the future land use designation of the property is mixed-use urban. This is a wellhead map that shows that there's some drinking water well within the vicinity. This is an aerial map that shows the subject property here. Now, there were several public hearing signs that were posted due to the size of the property. So this is our first one that was posted on Underwood Avenue. This is looking north onto the site from Underwood Avenue. This is looking north onto the site from Underwood, again. This is also looking north onto the site from Underwood. You're good. This is looking north onto the site from Underwood. It's further down the road. This is looking west along Underwood Avenue. And this is looking north onto the site. That storage facility appears to be vacant at this time. This is looking south from the site across Underwood. This is Pirate Field, if you're familiar with the area, a softball and baseball complex. This is also looking south from site across from Underwood. This is looking south along Tippin. We also put a public hearing sign on Douglas Avenue. So this is looking west along Douglas. This is looking south onto the site from Douglas. It appears that this house is vacant. This is looking north from the site across Douglas Avenue. And we placed another sign at the corner of Tippin and Underwood there for public notice. So this is looking onto the site along Tippin and looking south along Tippin Avenue. Again, looking south to kind of get an idea. The subject property would be to the right there. And this is looking across Tippin Avenue from the site, commercial complex there. And looking east across Tippin towards Executive Plaza Drive. That concludes our photos and maps. And if you'd like, I will proceed with staff's findings.
Yes, sir, please.
Yes. So the submission for the requested conditional use, they are seeking a conditional use approval to allow an active outdoor recreational center facility, a soccer complex, within commercial zoning district. Similar to the first case, this outdoor type of use of outdoor activity requires the Board of Adjustment review. Concerning criteria A, general compatibility, we found that the proposed use of an active outdoor recreational facility can be conducted and operated in a manner that is compatible with the adjacent properties and other properties in the immediate area. The property is surrounded by similar recreational uses to the south and commercial uses in the vicinity. There are a few residential uses north of the subject property, yet they are separated from the proposed use by a street right-of-way and wooded vacant land. The subject property is surrounded by Pensacola State College, and the proposed use is compatible with associated indoor and outdoor uses of the existing educational facility. Concerning criteria B, facilities and services, according to the application, the potable water and wastewater connections are available from Emerald Coast Utility Authority. Facilities and services are available and will be provided as needed for the proposed use, and the connections to these services will be reviewed at the development review stage. Concerning criteria C, on-site circulation, based on the submitted application, ingress and egress to the site will be utilized from Underwood Avenue and is sufficient for the proposed use, as Underwood Avenue is currently used for the existing educational and recreational use in the surrounding area. Pedestrian access improvements are shown on the submitted site plan and will be required along Underwood Avenue. Additionally, a mid-block crossing is proposed and will be further evaluated by County Transportation and Traffic Operations, TTO, personnel at the development review stage. Criteria D, nuisance and hazards. We found that outdoor bleacher seating areas are shown on the proposed site plan. The provisions of the Land Development Code do not allow making of noise or sound that exceeds the limits outlined in the LDC or the county noise ordinance. In addition, air pollutants, glare, vibration, and other nuisance hazards are addressed by the LDC and must be met. Other similar outdoor recreational uses are located in the area. The proposed use will be in similar scale and intensity as the adjacent properties, and offsite nuisances and hazards are not anticipated by the proposed use at this time. Criterion E, concerning solid waste. Solid waste service must be provided to the site, and relevant dumpster enclosure facilities are shown on the submitted site plan. All on-site waste containers will be appropriately located and screened from off-site visibility. Concerning criteria F, screening and buffering. As proposed, the site does not abut any residential uses, and therefore screening and buffering of the proposed use is not required. Criterion G, signs and lighting. Our findings of fact show that the LDC requires lighting to be located for safety and visual effects and must be installed as not to shine directly on adjacent properties and public streets or cause annoyance from brightness and glare. Signage for the proposed use will require applicable sign permits and must meet all county requirements related to size, height, and location as specified by the LDC and the building code. Signs and lighting will be evaluated for compliance with the Escambia County sign and lighting provisions during the land use review process. Criterion H, site characteristics. Our findings show that the size and shape of the site appears adequate to accommodate the proposed use. The site characteristics of the proposed use will be in similar intensity of the surrounding adjacent uses. The subject property is located in Pensacola Regional Airport height restriction grid, 270, yet the proposed use is not expected to exceed any height restrictions. Criterion I, use requirements. We found that no additional use requirements for an outdoor recreational facility are specified by the Land Development Code provisions. And finally, our staff findings. Staff recommends approval of the proposed use as requested, contingent upon site plan review and approval as applicable. That concludes our staff findings.
Do we have any questions for the staff? Seeing none. Sir, would you like to come back and could you tell us what you plan or what is planned for this area?
Yes, sir. So representing Pensacola State College, their primary main campus is just immediately south of this property on Underwood. The intent here is to develop a soccer complex, which is going to consist of essentially a field, some buildings that are going to support spaces anywhere from training to locker rooms to official rooms and bleachers, concessions. We will have a small parking area to support officials and coaches primarily, but most of the parking is intended to be on the south side of Underwood Avenue. Pensacola State, as we all know, is a pillar of this community, and this is just a request to help them continue in that role. So I will say, just for the record, that educational uses are allowed in the commercial district. The fact that we're doing an outdoor recreation use with this soccer complex is what's triggered the conditional use request. So we've tried to answer all of the criteria specifically in our submittal. Certainly happy to answer any questions that y'all may have.
Do we have any questions for the applicant?
I have one.
Yes,
What
sir.
are your expected operating hours?
I think that's going to vary by season. There are some representatives of the school here that probably have a better answer to that than I do. Operating hours, have they been established? gotta give them your name. Just give them your name and address.
Okay, Ed Meadows, 1000 College Boulevard, President, Pensacola State College. Hey, Mr. Cobbett.
How are you, sir?
I'm good.
Good to have you with us today.
Thank you.
Sir, could you be sworn?
The hours of
Go.
Sir,
Oh, I'm sorry.
hi. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
As any athletic facility, the hours of operation will depend upon the game schedule. This area will be lighted, so there's a possibility that there could be evening games as there are on the baseball field adjacent to this property. But most of the games will be played during the daytime. There will be some practice sessions on the field, but we have a practice field that's on the other side of Underwood that we're currently using for the soccer team. We have only one soccer team, it's a women's soccer team, but because of the nature of this facility, there is a possibility that community clubs that have soccer as their primary sport would be able to rent the space. So it would be possibly not later than 9 o'clock at night, but certainly during the afternoons and evenings and on weekends would also be the possibility.
Thank you.
I have a question also. This property, if my memory serves me, and the photographs show, there are some awfully big oak trees there. It's a shame if it's just clear cut and although you can't have soccer fields on hilly ground, I understand that part too. But what plans has the college made to preserve as many of those oaks as possible? Because it is lovely there. It's been a long time since I've been through that area, but if my memory serves me, it is.
Yes, sir. We own the 25-acre area that extends from Underwood all the way across to Tippin and then all the way up to the strip mall. And we have purchased that property with the intention of future college development for facilities. We have identified one heritage oak that is adjacent to the house that we'll tear down that belongs to the college. So our architects have positioned the soccer field so that that oak tree, that heritage oak, will be safeguarded. In addition to that, the college has the intention of not planting trees back where the soccer field goes, but as a matter of fact, we have a cooperative partnership with the city for them to donate trees to us this year. But we continually try to replace trees on our campus. So adjacent to the property that will be developed as a soccer field, there's an opportunity for us to replace trees that have been removed for the soccer field. But certainly that one heritage oak that we have will be in a good location for its preservation.
All right, sir. Okay, thank you very much. We appreciate your testimony. Do we have any more questions? All right, thank you, sir.
Yes.
I have can we go back to the slides, to the wellhead slide? This development isn't going to impact the wellhead, this area, is it?
It is not, and that's something that'll be verified by ECUA through review, but as far as groundwater resources, a soccer field's a pretty low intensity use. Others that might come into this commercial district could potentially have a higher risk to it, but given where we are in the wellhead, there will be wellhead protection zone, excuse me. There may be restrictions on the stormwater management systems that we're allowed to design, and again, that will all be confirmed with both ECUA and county staff as we go through the development order process. But from a groundwater resources perspective, a grass soccer field with relatively small buildings and bleachers is a pretty low-intensity use.
Yeah. If I remember right, there's a ECUA well
There is.
right there at the, well, near the, across from Sonny's, where the fire station is.
It's indicated on that map at Underwood and Ninth.
Yeah.
So right there down the street. Yes, sir.
And Lord knows we don't need any water quality issues.
Certainly not interested in causing those.
Do we have any more questions? All right.
Any speakers?
Oh, yeah, we do. Thank you, sir. Well, Mr. Meadows, Dr. Meadows has been with us, and Mr. David Alsop, do you wish to speak?
David, you want to say anything? That's the architect for the project. I think he's
All right.
opting
good.
out.
Good. All right, is there anyone else who hasn't given us a blue form that would like to speak? Now would be your opportunity. Let the record reflect that there are no others and all speakers have been accounted for. Thank you, sir.
Thank
We
you.
appreciate your assistance.
Mr. Chairman, I move that we accept staff's findings of fact and grant the conditional use.
I second, Mr. Chairman.
We have a motion by Mr. Smith with a second. And is there any further board discussion on this project? I think it'll be, my personal opinion is, I think it'll be a real boon to the area, and we certainly want to do all we can to support PSC. Since it is such an important part of our community. Given that, all those in favor of this application, please raise your right hand. Let the record reflect this passed unanimously. Okay. Give everyone a chance to settle down a minute. Since we do have a number of speakers, I mean a number. So, but having said that, it is wonderful to have so many people come out to express their opinion because the board is always anxious to know what the thinking of the community is on any particular issue. We will now turn to case number 2024-14, 5595 Highway 95A. The request is to allow a bar pit within 1,000 feet of a residential use. It's requested by Jeremiah J. Talbot, attorney for Andrew J. Patterson, the owner. And I am under the impression that we have attorneys here in this matter. Am I correct?
Yes, sir.
You are correct.
All right. I would ask that all the attorneys that are involved, before we get into the mechanics of this thing, could you please just come to the podium, make your appearance for the purposes of the record?
Jeremiah Talbot on behalf of the petitioner, Mr. Patterson.
Welcome.
I'm Philip Bates, sir, on behalf of Connors and Connor Holdings, an opponent of this particular application, and I have with me my colleague, Sarah Walton.
Hi, good morning. My name is Sarah Walton.
Yes, ma'am. And you are also an attorney, ma'am.
Yes, sir, I am an attorney. I'm with Philip Bates and with Connors and Connors Realty.
Okay, thank you very much. And I think that takes care of all our attorneys. It makes it easier on the clerk who has to keep track of these things. And I see we have a court reporter, and I hope that helps them also. First of all, welcome everyone. As I said, thank you so very much. When we get to receiving testimony, since we have so many, not that that's a bad thing, but there are a lot of things, and I know people have other things to do today besides being here. So I tentatively, the board's policy is to let everyone speak. And we try to let everyone speak to the extent it's not repetitious, as to get your full feelings about a particular question. But given that, and given the number of people that we have, I think today we'll initially try to limit our, when we get to this point in the proceeding, our speakers to 3 minutes. And I would say, if someone else has said your thoughts, it's not necessarily for the board to hear a repetition of the same thing. You can simply indicate that you agree or whatever. But at any rate, again, thank you all so very much for coming. And we are now going to begin. Board, has there been any ex parte communications in this case? Let the record reflect there have not. Is there anyone who has knowledge or information obtained from a site visit or other sources? Let the record reflect there are none. Ask if any is any board member intending to refrain from voting due to a voting conflict of interest? And we do have one. And Willie, would you like to now enter in your recusal?
Yes, sir. I filled out a Form 8B, and I will be refraining from voting. And I, Willie Kirkland Jr., hereby disclose on August 21st, 2024. And it has Section A, a measure came or will come before my agency, which you're supposed to check 1, and I checked insured to my special private gain or loss. Section B, the measure before my agency and the nature of my conflict in interest in the measures is as follows. And I'm the owner of WC Kirkland Trucking, and my trucks and my drivers from time to time visit pits in the area. I feel it's a conflict of interest to vote on this matter. And I would not be voting on this matter, but I will be engaging in conversation if need be on this matter at this time.
Okay, thank you. Please let the record reflect now that the board does have a quorum of 4 with the recusal on the record. So we thank Mr. Kirkland for that. Okay, why don't we, Mr. Talbot, I think you're representing the applicant. Ms. Talbot, you're, as you probably have already heard, if you'd like to make a brief opening statement, we'd be happy to hear it. Or we would be happy to get the county's findings on the record first. Then we'll be glad to do that, and then of course you can follow up, and then we will take it from there as to I'm sure there'll be questions, and we'll see where that leads us.
We'll go ahead and let the staff make their presentation first, and then
All
we'll
right.
address it from there.
Okay, thank you, sir.
All right, sir.
Yes, sir. Let's, let us hear yes, sir.
I'm Philip Bates.
Yes, sir.
I'm curious, do we need to qualify our expert before the hearing starts, or is that something you want to take up later?
I didn't realize you had one, so that's a good, I appreciate you rising now before we get too deep into our testimony. Board?
I'm sorry, Your Honor. Sir, if I may.
Could I just a moment, and I will give you full reign. I know you're gonna have some thoughts.
Yes, sir.
Board, this is a situation where, I didn't realize, and I don't think any of us did, we are going to have, I presume by Mr. Bates in the opposition, an expert will proffer, credentials on some subject matter relating to this. Mr. Bates has raised a question, do we wish to hear his expert's credentials now? Or would it be better to hear this testimony when we get to whatever the subject matter of his expertise is in Mr. Talbot's case? I'm sure Mr. Talbot's going to raise a point that this expert is going to try to rebuff. Am I correct, Mr. Bates? Am I correct?
I'm sure that, I don't know if he'll have objections to the qualification of our expert. And the only reason I brought it up is because I recall in prior hearings that the board took it up before we got started.
Yeah.
I just wanted to make sure I didn't waive it, that was all.
Yeah, no,
I
no,
don't
sir.
care when we do it, as long as it's at the pleasure of the board.
And Ms. Talbot, I know you had thoughts, so could we hear yours?
Yes, sir. My concern mainly, or the initial concern, is that this is a petition brought by my client to the board. Certainly, anyone has a right to stand up here and have their 3 minutes and talk and express their position to the board. But what I don't want to happen is that this be a bunch of people and the opposing side has an attorney, so now they get to present an infinite number of witnesses, they get to present experts, they get to go beyond that, they get to cross-examine. Essentially, I don't think the process should work that way, and does work that way, because then limiting anybody in the public to only 3 minutes, but allowing another objector to have unlimited time to ask questions and present evidence, I think is inappropriate. Okay, so, but I think they can, 3 minutes, they can present somebody to testify on that behalf. If they have an expert that wants to give his opinion, that's an issue. He gets limited to 3 minutes. But it's not 3 minutes to everybody else, and this side gets unlimited time. It's my client petitioning to the board, and the board hears the evidence, hears what citizens say, and makes a decision.
Yes, sir. I understand what you're saying. At this point, I'd like to hear from the board.
May I first just remind you of the rules of procedure that are memorialized in the resolution that applies to these proceedings, and they state in section 5.8, all interested parties must be afforded the opportunity to present evidence, cross-examine witnesses, and be informed of all the facts upon which the board acts. An interested party would be someone such as a neighbor, someone with standing who could appeal your decision. And so there are due process issues, so just keep that in mind.
And since we have representation essentially from at least one objector, that means that that person would be allowed to present their argument, of course.
That's a question?
Yes. Yes, ma'am.
Well, as stated in the resolution, all interested parties must be afforded the opportunity to present evidence and cross-examine witnesses.
Yes. So it looks, I'll tell you what, why don't we do this? Board members, do we want to go ahead and see what kind of expert we have here and whether or not they qualify?
I think we need to see that
All right, sir.
and declare that first if we're going to accept the witness.
All right, sir. All right, Mr. Bates, you want to bring your,
Well, I'll just, Mr. Merrill, come up. Mr. Merrill has qualified as an expert before this group. The last two times we've argued this particular issue. His curriculum vitae is Exhibit 17 in our materials, which we submitted yesterday in accordance with your rules. Mr. Merrill is a licensed professional engineer, and as I said previously, has twice before been qualified as an expert by this panel. If the panel has any questions regarding his expertise, number one, I'd be somewhat surprised, but number two, to the extent his curriculum vitae, which is Exhibit 17, does not address those, I'm sure Mr. Merrill could respond. I would examine Mr. Merrill, but I suggest that the time constraints, that would not be a good use of our time unless someone has a concern about whether he is indeed an expert.
sir, could you face the clerk? Give us your name and address and be sworn in.
Yes, sir. William Merrill, 1164 Finch Drive, Gulf Breeze.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Spell your last name, sir. Merrill.
And sir, what is your expertise that you would like the board to be aware of?
Well, as mentioned, the last two times I was qualified as expert. It relied on both civil engineering and land planning experience. I believe county staff here can attest to the work I've done in the last 30 years in the both land planning and civil engineering aspect.
Can you tell us a little bit about your education and your, well, you mentioned some of your experience, just briefly.
Yes, I'm a licensed civil engineer. I was almost 25 years in the state of Florida. I graduated Auburn University in 1994. I've worked almost exclusively in civil engineering and land development since then, including owning a business here in Pensacola and one in Gulf Breeze that primarily works with land development.
All right, sir. Mr. Bates, what will you be offering Mr. Merrill for?
Mr. Merrill will be testifying about the specifics with respect to this application in terms of the proximity of it to other relevant geographic features. Also, its characteristics in terms of what is proposed, in terms of both the pit, the features of the proposed pit, and other matters as he has testified to, again, previously before you in particular, and this board also the last two times. In the past two times, we haven't gone this far in terms of qualifying him as an expert. I think the staff generally recognized and did not have any objection to his qualification as an expert. I'm going to have him testify about what this pit is going to do, what it looks like in terms of borrowed pits, where is it in relationship to residences, wells, wetlands, those kinds of things. Also, he will testify about provisions of the Land Development Code, the similarity of this application to the other two, the likely duration of the pit operation, the existence or not of any feasible buffer, and the proposed or feasibility of the proposed reclamation.
All
Those
right.
are things that I've believe the county staff, which has been qualified or unqualifiedly qualified as an expert, are also testifying. So I would say that's the subject matter.
Okay. Mr. Talbot?
Your Honor, I think very specifically, or I say Your Honor, I apologize. You don't just qualify somebody and say they're an expert. You have to be an expert in specific issues and specific experience, okay? There's no question that he is an expert as a civil engineer, all right? However, some of these other items they want to talk about, the wetland development items, proximity to wells, stuff of that nature, is not necessarily within his purview. Land development is not within his purview. As a civil engineer, he has authority there. However, if they're able to get that within 3 minutes, like everybody else is limited to here, then I think he's just a witness. He's essentially somebody from the, to present testimony on behalf of the board, okay? And so I do not think that one of the important points is he limited to 3 minutes? Because they're not a party to this case. He's just like anybody else here that's gonna speak. And we don't want to get this into a circus and an hour for every person who wants to stand up here and talk. So I think that's some of the important characteristics that we have to address.
Mr. Godwin, if I could elaborate, Mr. Talbot could not be more wrong about the prerogative of my client to appear and speak. The assistant county attorney alluded to resolution of the Board of County Commissioners, which establishes the procedural protocol for this group. And among other things, we have the right to present witnesses. We have the right to cross-examine the applicant's witnesses. We have the right to present expert testimony. All of that is set forth in resolution number R96-34 in March 1996. And that has been the procedure that has been followed by this Board of Adjustment at least the last 2 times that Mr. Patterson has made this application. Mr. Talbot simply has not read or does not appreciate what the county attorney or assistant county attorney alluded to earlier, and that is we are not limited to 3 minutes. We have the absolute due process right in front of a quasi-judicial proceeding to present our side of this case.
And our counsel does not understand the law, all right? What is going on here is he wants to say he has infinite time to intervene in this case, but every one of these people are limited to 3 minutes. Something about him is so special that he gets to stand up here, he can present testimony. But if these people are limited, then so should he as a person, as a representative, as an objector. We don't want to get this into a circus so that because each one of these people could bring their own attorney and present 50 witnesses and cross-examine. Is that what we want to go into? I don't think so, all right? Because if you say they have a right to cross-examine witnesses, and then so does everybody else, okay? So I'm aware of the quasi-judicial process, all right? But they should be limited like anybody else. It doesn't say you're limited to 3 minutes, okay? It says, it doesn't say they can't present their testimony within 3 minutes, but they don't get an infinite time to do this and to turn this into a circus, and that's exactly what they're trying to do.
Mr. Chairman, it would appear that the board is going to need to declare an expert witness on more than one topic. That's not usually the case. And it may be such that we declare an expert based on desired testimony of the
I think Ms. Smith raises a good point. I've also had some thoughts along the same line. I don't know what we can declare him an expert in until we actually get into the testimony and he's offered some testimony on some subject matter. I mean, I have no doubt in my mind, it's been a while. I, of course, have gotten the exact record from the last appearance. I know that he was declared an expert. I see no reason why he would not be declared an expert again. As to the subject matter, he certainly, in my opinion, is an expert in civil engineering. Now, whether or not these other things that Mr. Bates has brought up, these are specific topics that we haven't gotten to. We haven't heard Mr. Talbot's presentation on those, and at that point, I don't know how we can declare him anything other than an expert in civil engineering, and we'll see. This is my thoughts. We could see where that takes us when we get to the actual testimony.
That being the case, does the county have any objection to the credentials of Mr. Merrill?
County does not have an objection to Mr. Merrill. He's, in addition to the two previous cases here concerning this, he's worked with us for years and has testified before this board on as an expert on multiple other cases.
I think that.
If I may, and I would like, as director, and I would like to support what you were saying. Definitely in the area of stormwater management, he has presented plans to the county, certified PE engineering plans for the county. He had made other presentations to the planning board. And in the area of stormwater management, design systems, staff definitely concur with that. In the area of stormwater management and design systems, he, as with planning board, other rezoning cases, clearly and definitely, the staff support that area of expertise and that area of subject matter.
Mr. Chairman, Mr. Chairman, I'm old. I think maybe that, Mr. Smith, that I would be glad to hear a motion to approve and accept Mr. Merrill as an expert in civil engineering, and let's see where it goes from there.
And I would like to make that motion.
Second.
We have a motion and a second to accept Mr. Merrill as an expert in civil engineering, and we will, when he testifies on whatever subject matter, we can weigh it at that point, if that's agreeable with the board. All right. All those in favor of this motion, please raise your right hand. All right, let the record reflect. Mr. Merrill, we will accept you as an expert at civil engineering.
Thank you, Mr. Chairman.
Okay. Does anyone remember, before we get again into this, in the last hearing or the hearing before, did Mr. Bates, did your client appear, or did you intervene formally?
My client I filed on my behalf and on my client's behalf a notice of appearance before this group, both this time and the last two times. It's not an intervention, it's an appearance.
So you never filed a motion to intervene into?
No motion to intervene is required.
Okay.
The resolution, and I didn't put it in evidence, I don't believe. It's, the resolution, yes it is, it's item 16, which is the rules for this administrative hearing by the Board of County Commissioners.
I'm gonna let them know.
Allows us to do precisely what we're doing. It's not an intervention. So,
okay. We've had these before, and oftentimes there would be a motion to intervene. That's fine. I just couldn't remember whether or not you did it.
Mr. Chairman, this isn't an administrative appeal case. This is strictly a conditional use.
I know that in the past we've had this kind of thing come up before. All right, thank you, Ms.
Thank you,
Bates.
sir.
I appreciate your thoughts. Could we hear from the staff? We're talking about something that we haven't really heard the particulars about, and I don't think we can go forward until we actually get exactly on the record what the matter is before us.
All right.
So, Andrew?
Yes, sir. Andrew Homer, Escambia County Development Services Department. This is conditional use case 2024-14. Here we have our location map, the red outline showing the petitioner's property. It's located there along North Highway 95A, which is a collector road. Here we have a zoning map for our site. The parcel in question is zoned agriculture. You see the parcels immediately to the north and south are both zoned agriculture. So for each zoning district, you have your permitted uses and you have your conditional uses. This is somewhat unique. It has all your regular permitted ag uses, anything agriculture, livestock, whatever is just permitted outright. Borrow pits, as long as they meet certain requirements, are permitted outright. The situation here, and I will go into it in the findings, is there's another section of the code related to borrow pits that requires this conditional use process if it is proposed to be within 1,000 feet of a residence. This is our future land use map showing it is rural community. Aerial map of the site showing the wetlands off to the west. Public hearing sign posted on site. Looking into the parcel from 95A. Looking north along 95A. Looking east from the driveway of the subject property. And that's looking south along 95A. And that concludes the photographs. As to the findings in this matter, I'll pull that up. So the applicant has submitted their package and their exhibits, as they are the applicant, requesting a conditional use to allow for a borrow pit within 1,000 feet of residential uses and zoning. As I explained, that provision falls under a different section of the code. It's 4-7.6, and you can see it's up there under the relevant authority. As to the specific criteria for conditional uses, first one is dealing with general compatibility. This proposed use is in an area of mixed residential and agriculture uses. As proposed, the operation will have higher buffering standards than those required by the Land Development Code. The increased buffering and strict adherence to the LDC requirements for hours of operation and dust suppression will allow for compatibility with the adjacent uses for the period of active mining. While the proposed reclamation for the site is a lake and residential home, the proposed reclamation must be approved by the Board of County Commissioners prior to the commencement of mining. This will require a full site plan review through the Development Review Committee in adherence to all LDC and Code of Ordinance standards, including those outside the authority of the BOA. B, facilities and services. The services needed for operation of a pit will be provided by the operator. As proposed, the operation will not need the use of a potable water supply or a sewage system. Information obtained by the applicant indicates there are no public potable wells within 500 feet of the parcel. This was confirmed by a staff search of the Florida Department of Environmental Protection online mapping system. On-site circulation. A proposed driveway connecting to North Highway 95A should be sufficient to service the proposed use. The trucks accessing the site would use the road in a similar manner as those servicing other pits and industrial sites in the area. Nuisances and hazards. Nuisances associated with a mining operation can be alleviated through strict adherence to the development standards imposed by the LDC and the County Code of Ordinances, Chapter 42, during the active mining period. These standards will be imposed during the DRC process along with BCC reclamation approval. Solid waste. Any solid waste services required will be provided by the operator. Screening and buffering. The LDC contains use-specific setbacks, screening, and buffering requirements in Section 7-4.6. The proposed site plan shows a 25-foot natural vegetative buffer around most of the pit, widening to 50 on the southern border. This will be supplemented by fencing and additional plantings as required through the site plan review process. Signs and lighting. The proposal for this pit details an entry sign with hours of operation and contact information. The only other signage will be no trespassing signs as directed by the LDC. No lighting was included in this proposal. Site characteristics. The overall parcel size is 52.85 acres with 44 plus or minus acres proposed for the pit. The submitted site plan shows the pit centered on the wider portion of the parcel and uphill from the wetlands to the west. The site appears adequate for the use as proposed with the enhanced buffering. Use requirements. Conditional use requirements for borrow pits are found in LDC Chapter 4, Article 7. These are dealing with the nature of it. It's sites requiring access from adequately wide paved roads. They're on a collector road. There are no local streets that would be used. The scale intensity of operation shall not generate unreasonable noise, odors, traffic, dust, or other potential nuisances. We've covered how that is going to be handled, and details for that will be enforced during site plan review. We've got the applicant did submit a boundary survey and description of anticipated excavation phases, and they meet the other assorted additional requirements as you can see there. When we come down to E, it does point out conditional use approval pursuant to this subsection does not waive an applicant's duty to meet other county, state, or federal permitting requirements or performance standards. And F, there you see where we find the reason why we're here today. It is within 1,000 feet of a residential use. Additional standards regulating mining and reclamation activities are found within the Code of Ordinances in Chapter 82 and 42. While these additional standards are outside the BOA scope, they will be reviewed and applied during the permitting process. As to the findings, staff recommends approval of the conditional use as submitted with the enhanced buffering as detailed on the submitted site plan. DRC site plan approval and BCC approval of the reclamation plan are required. And that concludes staff's findings.
Thank you, sir. Does the board have any questions at this point? Mr. Talbot, would you like to make a presentation?
I would like to cross-examine him.
Oh, you would like cross-examine staff?
Yes, sir, briefly.
Okay, go.
Sir, I just want to emphasize a couple points. Number one, you said it's zoned agricultural, correct?
That is correct.
And under the Land Development Code, has the Board of County Commissioners presented or identified whether borough pits are permissible in agricultural areas?
Yes, they have.
So the BOCC has already determined that if we have a borough pit and it's in an area larger than 20 acres, it is permissible.
With this exception for conditional use with 1,000 foot.
Now, you mentioned a collector road. What is a collector road?
So we have different levels of roads. Can you go back to the location map, please? And can you get to the, if you could zoom in on the legend somewhat, bottom corner. So roads are defined through our system and with FDOT by their use. You have your principal and minor arterial roads. These are usually your main traffic carriers. Then you have collector roads and local roads. Local roads are your local streets the houses are off of. Collectors are fed by the local streets, and they then feed arterial roads.
And the collector road in this situation is Highway 95A?
That is correct.
State highway or federal highway?
I believe it's state.
Okay.
I would have to check that.
Is there already commercial vehicles operating on this street?
Yes, sir. It's collector road for that side of, that northern side of the county there. So anything coming off driveways, anyone going north or south is going to be feeding to that
Would
road.
that include dump trucks?
Yes, sir.
Okay. If staff can go to the picture looking south of the sign. I think that's it. One up. There we go. Yes. If you look in the very back left, do you know what that is in the back left?
I'd have to get it zoomed in. I'm sorry. I see a vehicle, of some sort.
And does it appear to be a dump truck?
Can you zoom in? Okay. Yes.
Okay.
Yes, it does appear to be.
And at least this picture evidences that dump trucks use this road, and it definitely when y'all happen to take this picture, correct?
Yes, sir. There's other vehicles as well. I mean, obviously you have cars, vehicles servicing agricultural uses in the area, garbage trucks, school buses, lots of large vehicles, because it's the collector road for that area.
Yes, sir. And you said that the usage, they would not have to go through residential roads in order to access this road or access this property.
That is correct.
Sir, you mentioned the buffering. The buffering that is proposed in this case is wider than what is under the LDC?
That's correct. It is on the south side there.
And that would help protect any issues or any potential problems that could arise because of using this property, correct?
That is the function of a buffer, yes, sir.
Now, sir, my client has indicated that he wants to use, after he digs this pit, he wants to use this as a pond. Is that correct?
Correct.
And there are other ponds in this area, aren't there?
Yes.
He is not planning to bury anything toxic there, construction waste, yard debris, anything of that nature. Is that correct?
The proposal is the reclamation to be a lake, but once again, that does require BCC final approval.
Yes, sir. All right. But I just want to make sure that if somebody has passed out flyers indicating that they were going to put toxic or somehow put deleterious items into the ground, that would be incorrect pursuant to the plans, correct?
That is not what was submitted.
As well, if this board is to approve my client's request, it would still require DRC approval, correct?
Yes, sir.
You would still have to go through the board and the BOCC, correct?
That is correct.
You'd also be able to subject to regulation by the county on a yearly basis.
Let me step back one.
Okay.
It does require DRC. It requires BCC approval for the reclamation plan. The Board of Adjustment can approve the use of the land, which is what we're here for. Sorry, didn't mean to.
And at least if this is approved, then the county will regulate my client, correct?
That is correct.
He is submitting, asking for the county to regulate his use of this property, correct?
Yes, sir.
And that would be subject to popping in and looking to see what he's doing, correct?
We do inspect, yes. Yes, we do.
And that would be subject to, this would be a, what, 4 or 5 year permit?
I believe at this time it's a 5-year permit.
Nothing further.
Okay.
Yes. Thank you, Bates. Mr. Homer.
Hello.
Nice to see you again. Were you the staff presenter for the first hearing in 2021?
Yes, I was.
All right. I knew you were in 2022. I didn't recall if it was 2021 also.
I remember. I wouldn't say fondly.
What is the difference? What is the difference in the size of the pit or the size of the parcel of land on which the pit is to be located in the current application as distinct from the prior two applications?
I'm just going with the current one.
No, but I mean, it's the same size pit, is it not?
I believe so. I'd have to go look at the case files from the previous ones, but I believe it's the exact same plan.
Same size pit on the same size parcel of property?
Yes, sir.
Okay. how many residences are within 1,000 feet of this parcel or this proposed pit?
I don't know.
The application says 1, does it not? Or the staff analysis says 1?
I don't recall mentioning just one, no, sir.
With respect to this parcel, do you just look at adjoining parcels, or do you look at parcels within a larger vicinity of the pit in determining whether or not it is consistent with the prior existing permitted uses?
Sure, the general area.
Okay. Have you been out there?
I have.
Have you gone on the property as distinct from, looked at the property from the road?
No, sir, I have not gone on the property.
Have you been out to the property, I guess would be on the northwest?
No, sir.
Other adjoining residences?
No.
With respect to this particular borrow pit operation, it is going to be 40 to 60 feet deep, is that correct?
I would have to go back and count the contours, but I believe so.
And that would be over a 44-acre tract of pit?
Yes, portion of the parcel.
About 80% of this property is going to be the pit, right?
That is correct.
Okay. How long will it take to excavate 44 acres, 60 feet down?
That's going to depend on the market. I believe the proposal is to sell the dirt. If the housing market slows down, it could slow down that process.
So we don't know how long this borrow pit will be in operation.
No, sir.
Do we know, with respect to the reclamation plan, do we know who drafted it?
I do not.
Do you know whether or not the applicant is a limited liability company or an individual?
I do not.
Would that make a difference to you in terms of a reclamation plan?
No, sir.
Why not?
Reclamation plan is not this board's purview, that's the BCC's.
Isn't the board's purview to determine the compatibility of this application with residential use?
Of the land uses in the area, yes. That's why it's a conditional use.
There is no point in asking about reclamation if it's not within the purview of this board, is it?
The reclamation plan is simply that, a plan that was submitted as part of their application.
Okay, but you submit the plan to the board, are they just supposed to ignore it? Is that a component of all this that is just surplusage?
So I did mention there are other parts of the borrow pit and reclamation process that are outside the purview of the Board of Adjustment. The reclamation plan is something that has to be done, okay? The BCC mandates you're gonna dig a hole, you're gonna need to tell us how you're gonna fill it up, grade it down, what you're gonna do at the end. And that goes to the BCC. That's why it's
Also
kind of,
goes to the Board
it
of
crosses
Adjustment,
both.
does it not? It's part of the application.
They have to propose one. It's not the final accepted one until the BCC signs off.
All right, so when they're asking about having a lake and a house at whatever time in the future they get through operating a borrow pit, that's just ethereal.
It's their proposal at this point.
It could change tomorrow, could it not?
It could be mandated to be changed by the BCC, sure.
Or they could elect to change it.
If conditional use approval is granted by this board, the use of the borrow pit would be allowed on that property, okay? Again, the reclamation plan, as proposed, would have to get final approval from the BCC.
What I'm saying is, and we're talking about two different things. This reclamation plan has been submitted, and we're told they want to have a residence and a lake. But that's not a condition of the approval of the conditional use, is it?
No, because that final authority isn't with this board.
All right, so why is this board told what the reclamation plan is? Is it just irrelevant, but we submit it anyway?
It's giving this board the proposal, kind of like in a rezoning. All right, rezonings are not site plan specific. Someone could come in and say, hey, I want to build a Chick-fil-A. Once the zoning gets approved, anything allowed by that zoning could go in there. So it's one of these things that's a background item for the board, so they can get a look at what is proposed.
If the applicant is an LLC, or the owner is an LLC, do you know what an LLC is?
Limited liability company.
And is of indefinite duration?
I don't believe so.
Mr.
Okay.
Bates, we're getting a little bit of,
Well, I'm trying to get to the, I'm
we're
sorry.
getting a little bit of feel here.
Okay.
And as to the reclamation plan, if my memory serves me right, in the last hearing, the matter of the reclamation plan came up, and there was some photographs proffered of it, and the board voted not to consider that particular submission. So we understand that it's part of the protocol, but it's not within anything that we have control over. And I appreciate your trying to build your case, and honestly I do, but I think some of your questions to Mr. Homer are better set to the Mr. Talbot's expert or Mr. Talbot's witness. I mean,
As far as I'm concerned, Mr. Godwin, I'll stop with the questions having to do with the reclamation plan if this court's not, or if this board is not going to consider it. That's fine.
as I said, I want to give you the opportunity to explore whatever avenues you deem necessary, but I've sat here and I've listened to your questions. A lot of them to Mr. Homer are the kind of things I would anticipate you would want to put to whoever Mr. Talbot is going to offer.
I don't know who he's going to offer, if anyone, so I'm trying to determine. I understand that the staff constitutes an expert and that the staff has made a recommendation. I'm trying to ferret out the predicate for the staff's opinion, and I apologize if I've gone too deep into the weeds.
Yes, sir. Well, you just might ask that. Sometimes the simplest way out of the barn door is to open it. So,
I will ask, what buffering do you contemplate as the prerequisite to the conditional use approval?
At this point, they're proposing fencing and leaving natural vegetative buffer. I'm sorry. At this point, they're proposing fencing as required by the code and leaving the natural vegetation that will be reviewed in DRC and may need to be supplemented.
Will natural vegetation buffer dust?
It's vegetation. If it's trees are pretty tall.
What I'm getting to is that the pit is the same distance from my client's property as it has been in the two prior applications. And what you're saying is they're going to put a fence up and they are going to have natural vegetation. And I'm asking you as the staff expert, is that going to be sufficient to keep dust over the term of this particular operation from going on adjoining properties?
We will probably be requiring additional dust suppression measures. Once again, these are based on natural events. The amount of dust you got coming off a construction site, well, we've been pretty dry for a while. A truck driving across dirt is going to stir up dust. If we've had a rainy season, not so much.
In terms of this board's task of determining the compatibility of a borrow pit to the adjoining, plural, residential locations, including at least two abutting this property, you have said this is going to be, the staff approves this one because of additional buffering. And in fact, from what you've said, there's no additional buffering at all All there is a change in the line on the map.
Right, buffering is based on width.
And do you think that, as I recall your general compatibility findings, the operation will have higher buffering standards than those required by the Land Development Code. The increased buffering and strict adherence to LDC requirements for hours of operation and dust suppression will allow for compatibility with adjacent uses. What exactly is going to be the dust suppression system that is going to make this compatible?
Dust suppression would consist primarily of spraying down the dirt when it gets too dry.
Is there a water access on this property? As I recall, there was no water on this property.
I believe they would have to sink a well.
Have they done that?
I do not know.
Is sinking a well going to be a condition of this being a sufficient dust suppressant?
As part of
Bates,
the conditional use, or are
I'm
we
sorry
talking
to-
DRC?
Mr. Godwin?
We're going in circles here, Mr. Chairman.
Just a sec. Ms. Bates, I don't like to do this, but you're asking questions now that the applicant should be answering. And I don't know that how Mr. Homer is going to know about a well. This is not his project. Why don't you?
This particular, excuse me, Mr. Godwin, the staff has told this group in 2021 that they didn't think it was consistent with the approved residential use. And the board voted consistent with the staff. The next year, the staff came back and said, no, we think it's now consistent with that use. And this board voted 6-0 against that position, talking about the very criteria that staff had discussed then. And today, staff is once again saying they think this is consistent with and okay and is not going to be a problem for an adjoining residence, and that's just not true. They don't have any, they are supposed to give you findings of fact, and they have no predicate for giving you findings of fact. They don't know what is going to happen.
No one does. That's quite a bit of assumptions you're making.
Mr. Homer.
Sorry. Yes, sir.
My point is that the line of question, and I appreciate your goal, I truly do. But what you're asking him, in my opinion, is questions that should be in Mr. Talbot's applicant. And then the applicant is going to know whether or not there's a well there, I would hope, and what plans he has for dust suppression. Those kind of questions, I honestly would submit to you, belong to him. Now, Mr. Homer is giving you answers that, as best I can tell, some are just generic. Trees hold dust. Well, that's true. But that doesn't talk about the trees that we're concerned about, the buffering.
And they don't say trees.
Or bushes or whatever. So.
But this recommendation is what your board is going to be relying upon in making its decision.
Well,
and this recommendation is uninformed.
That is true and not true. It is true that our board takes these recommendations seriously. But our job is to give both sides, or if there is a controversy, the applicant a full and fair hearing in which all evidence is accepted, and we weigh that evidence and do our best to apply the law as we understand it. And as I said, right now, I would just ask you to, you have a full right to examine, of course, Mr. Homer, But I would, it would seem to me, things that he doesn't really know about and is just giving you a generic answer for is not what we're here about. Mr. Talbot's, it's his burden to tell you all about wells and dust and traffic and whatever else he wants to talk about. And then you have the opportunity to cross him or his representative. So that's,
Again, Your Honor, I'm falling into the same trap. We're used to addressing judges. I don't mean calling you Your Honor to be a pejorative.
No, that's all right. I've been called worse. Truly, I have.
Mr. Godwin, what I'm trying to say is that staff's, quote, expert opinion, close quote, is nothing more than just an unsupported conclusion.
Okay, well, if you want to ask questions like that, that's different.
Well, in order to establish that, I've got to show that the witness doesn't know these underlying facts.
You know, if I can, this is to determine if the use is going to be permitted. They have the DRC, which is going to sit down and make the decisions and talk about how many trees, how big of trees, how wide of a buffer. That's the decision of the next committee.
That's true.
And that's not for this to try to beat up on this witness, because they don't have the exact plan of what's gonna go, how many trees, what color trees, will they be flowering trees, they can bloom in the summer and the winter. That's what he's trying to do. That's the next committee, they will address it there, not here.
Well, you're correct, but also it's the applicant's burden to talk about those things, at least in generalities. I've taken up some of your time, and I apologize. If you'd like to continue.
I apologize. This is what we went through the last couple of times. I thought we'd have to go through it again. If what this group is saying is that staff's conclusions are not supported by underlying facts that the staff is aware of in reaching those conclusions, that changes the complexion of what we're doing.
No, I'm not saying that.
Okay.
I'm just saying that this board is an independent body that makes its own decisions based upon all the evidentiary submissions from every individual or applicant and the staff, and we take that and we decide.
Okay.
And that's all. That's my point. And other than it is my dedicated job to make sure that everyone that appears before us gets a full and fair hearing and is able to express whatever thoughts and issues that they may possess, or he or she may possess.
All right. With some trepidation, then, if I may proceed.
Yes, sir.
I've got to ask about the wells. Did staff consider private wells?
Can we pull up the FDP exhibit, please? Yeah, that one first. So this right here, as you can see, is a zoomed-in map of the area. This is from the Florida Department of Environmental Protection for public water supply wells. There are none.
I asked you about private wells.
Yes, next photo.
Okay. Sorry to interrupt you.
Private wells. From generalized data from FDEP. I don't see any on there that's in their permit records. Now, we did go through this before in the previous exhibition. There is a code section north of 196 discussing protections for public potable water supply wells. There was a question at that time. Did that language apply to private wells? There was an interpretation made in 2022 by our department director as in keeping with the Land Development Code that section applies to public potable water supply wells.
You recall that you and I went through ad nauseum the definitional.
Oh, we did.
Okay. And you recall that the particular portion of wellhead protection that applies to private wells north of Barron Park Road is not cited in the interpretive opinion that was given to the staff. Is that correct?
That is correct.
Okay. So when it says any wells north of Barron Park Road do not have the benefit of a 7-year time of travel mode shall have a 500-foot radius zone, if that applies, and if my client has a well within a few feet of this site, does that preclude approval by this group?
I don't have any record of permits associated with that well.
I'm asking.
I can't consider things that the state says they don't have a record of.
There is testimony that you heard twice before from at least 2 different adjoining landowners testifying that they have wells on their property. My question to you, it is perhaps a hypothetical, but if those wells do in fact exist and they are private wells and they are within 500 feet of this pit, the conditional use cannot be approved under the existing LDL.
Again,
I'm gonna object.
let the applicant, please.
Mr. Talbot has.
This is an irrelevant issue because the definition in this regulation has already been interpreted by the director. That was not appealed, so therefore that finding is established. So there cannot be another argument that, oh, it happens to a private well that happened to be unpermitted, that we happen to just maybe feed to our horses. It's irrelevant to this matter. The statute talks about wellhead protection area and defines potable public wells, okay, in the well fields. Again, the director has interpreted it. It's res judicata. They can't relitigate that issue.
As Mr. Holman testified, Mr. Godwin, the interpretive provision did not apply to what I'm asking about. Once again, as a hypothetical, if there is a private well within 500 feet of this project, is it susceptible of approval under 4-5.9 C restrictions?
Let me look that up.
This is actually B3. In fact, if you would turn to Exhibit 13, maybe we could get Exhibit 13 that we've submitted up there.
No.
Can we
Wait.
get a ruling upon our
You haven't
objection?
that hasn't been accepted yet.
Okay, where are we now? What?
Can we get a ruling upon this rule, section 4-5.9, wellhead protection? That is within the same chapter as the definition of wellhead. And the wellhead protection area has already been interpreted. Maybe not this individual section, but the definition and the application of section 4-5 has already been interpreted. And so therefore, him trying to ignore everything previously in the section is not proper. And it's a waste of this board's time.
That is false. This witness testified that the interpretive provision, which is included in the materials submitted by the application, refers to a provision which is not the provision I'm asking about. It refers to 4-5.9A. It does not refer to 4-5.9 as.
I think.
It doesn't. And so there is no interpretive ruling that prohibits these
just a
questions.
minute before we get too deep into this. I think you meant to say that you considered Mr. Talbot's remark incorrect.
I thought I said that.
I don't believe you meant what you said, but I'm sure you meant that his assertion was incorrect.
I don't recall what I said, and if it was ugly, I apologize.
Well, I'm sure. I mean, we all, in the heat of battles, sometimes misspeak.
My point is that this witness testified precisely the way I'm arguing to you all, and that the interpretive provision does not apply to 4-5.9C. It applies to 4-5.9A and B. And so the question is, if the interpretive provision does not apply to item C, and if item C is in fact relevant. And if there is a well within 500 feet, is that an absolute prohibition on approval of this conditional use? And I haven't heard the answer.
Show me the well. There's the map from FDEP.
The question is, if there's a well within 500 feet, is it a prohibition on approval?
If it's a permitted well.
Oh, I didn't
I
see.
can't track down every single well someone drills.
It doesn't.
What standard should I use at that point?
Well, I'm not sure. I'm looking at the land development code, and it doesn't say anything other than any well. And we went through that definitional issue last time.
We did.
Well is, there's no adjective in front of well. And it doesn't say well that you all might be able to locate. It says if there's a well, you can't approve it.
If I
Okay,
may,
show me the,
I'm examining this witness,
I got it.
and Mr. Jones is interrupted.
that's what I'm saying. I'm the director, I make interpretations.
And the answer is?
I'm sorry, restate the
If you-
question?
If you don't know the answer, you don't know the answer. This
I
is
may.
really,
We're
you're
going in
asking for a
circles
legal
once again.
conclusion, I think.
It's a conclusion that they have sought to include in their application. And that's why I'm attacking it, because
My
it's not a
application?
legal conclusion, it's a qualification for conditional approval.
I'm sorry, I did not submit an application. The people who did, we haven't had a chance to hear from yet.
Yeah.
Remember,
Andrew.
it's not my case to make.
Andrew.
Yes, sir.
If you don't know the answer, then just,
I don't know.
all right.
That's all the questions I have.
Okay, I'll tell you what, it's now almost 10:30. Why don't we take, 10 minutes? I'm sure everybody would like to stretch their legs or get a drink of water. I think that might be helpful. Ms. Talbot, you'll be up when we come back and in session, and you can present your case.
Yes, sir, thank you.
Yes, sir. I need to, I'd like to go.
Well, the comprehensive plan is not the intent of this particular procedure is speculative. It was another form or another process that we did, but not this procedure. Because this is specific, this specific now you definitely I know the procedure, Mr. Bates. I've been doing this a long time. I know honestly, I was not first. I was going to actually empathize with this competition. Educate, ask the Mr. Bates, I don't respect Bates. I cannot coach nobody back. I cannot coach nobody back. Now you make orders, Mr. Bates, Mr. Bates. Yes, when they say about, yes, I do, but that's between that person and I'm not coaching of no one. Okay, I know the procedure.
I wonder how many times can you keep bringing this up? Every 180 days, you bring it up again? Yes, that's ridiculous.
Yes, that's ridiculous. That's ridiculous. That's the process. That's the process. We don't respectfully, it may be done, it's still the rule of the law. I can't help it. But it's just the people, I just, the BOA didn't have a conclusion. That's the, these were the will of the people. The BOA, they didn't. And you've been Mr. Bates on this. The BOA, we make fine based upon what we can.
I've been here 40 years.
Am I allowed to approach the bench?
I'm on 2 water tables. 6 to 26.
Can you ask how many
The
of
whole
us
watershed.
for the
All in my
1,000
property.
feet that got these blue cards to do the speak?
In August. Okay, he goes.
And I think that'll answer a lot of questions here today. Because I didn't get one last year for the June 2022 meeting. I never got one, and I'm within several feet.
I tell you what, talk to Andrew, he's the fellow that knows the ins and outs.
Everybody. I'm just. Yancey drilled our wells. Yancey has drilled our wells. He knows all along. Water company 30 years ago changed that law about my property. Not because of what's on top of it.
I'm a little salty.
Yeah, that's right. That's right. You know, hey, you know, you're not gonna have me to keep around. Yes, sir.
I don't know.
I don't know. I don't miss it.
Sometimes they don't make any changes. We'll see. I just, and they're way coming to do a lot of changes there, so see what happens.
Yeah, I hate to see, I mean, you're gonna have couple of new board members.
All when it comes to the PRC process, county, yes, county should discipline. Well, now they can bring it up, but it's already, that decision already rendered. Respect to each of you. I'm not saying it's right.
So I came up here to tell you that.
Okay, well, county commissioner. Oh, he wasn't, he's write-in or something?
Oh, yes.
All I'm
Yes,
that's,
got it.
he has a special.
Oh, yes, we do. That's what I'm saying. You don't believe it.
He had no idea I would be there on it, you and I would argue for so long.
Well, we are where we are, and I can't. You did your duty, you know. Okay, everyone, could we take our seats?
Okay, thank you.
Could we, ladies and gentlemen, can we get back to our seats? And we appreciate everything.
Are you in the mic, Mr. McConnell? The mic. We can't hear you.
Could everybody take your seat now? And I think we're ready to get started again. And we are, again, appreciate everyone being with us. Okay, Ms. Talbot, I think it's time at this point for, if you would, to present your case, what you intend to do what the project will accomplish, and whatever witnesses that you have
Yes, sir.
that, can explain to us exactly what this is about. We've kind of heard it backwards so far, and this is your opportunity. I think we need to hear from you, so we'll know what exactly, we've heard what's wrong, but with it now, we'd like to hear what it's all about.
I would, if Mr. Day I saw was here, is he gonna present testimony?
Mr. Day is available if needed.
If we can, yes.
Mr. Day? And please be sworn in.
We're glad to have you with us.
Yeah, good morning, Board. Tim Day, Deputy Director, Natural Resources Management.
Please raise your hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Sir, where are you employed?
With the Escambia County Board of County Commissioners.
And what is your position as Deputy Director of Natural Resource Management?
I am in charge of overseeing environmental issues within the county.
Are you familiar with this case we're dealing with today?
I am.
Are you familiar with the regulations with regard to burrow pits, wells, and so forth in the county?
I am.
And are you familiar with the interpretations with regard to wells, burrow pits, et cetera, in the county?
Yes.
Now, I want to ask, there have been some testimony or some cross-examination from counsel a few moments ago. Are you familiar with section 4-5.9 of the administrative code or the
Land development. Yes.
Does that deal with wellhead protection?
Yes.
I'm going to object to this witness. If he's going to give a legal opinion, it's not within the purview of his expertise.
Well, I'm not sure he's going to give a legal opinion. He can give his understanding of what he believes the regulation says and how it's applied.
As an opinion, it's something that an expert would opine to. He's not, nor would a legal expert be admissible.
I don't.
Mr. Day has been accepted by this board multiple times as an expert witness.
I know, Andrew. Well, first of all, Mr. Day is an expert. Nobody's asked that he be sworn in as an expert, but he is certainly, is an expert, and at least in my opinion. Mr. Talbot, did you want to offer Mr. Day
Yes, sir. Well,
as an expert in?
The county ordinances, and at this case, the Wellhead Protection Act, and the application submitted today. He is natural resource management, which would include groundwater, the boundary disputes, the zoning issues, all related to this case, because that's what he does for a living.
All right, Board, we've heard what is an offer of Mr. Day as an expert. In my mind, there's no question that he certainly is an expert. He's well-known in our community and has served this county with distinction for many years. So,
I don't take issue with the quality of his service. I don't take issue with his honesty or his character or anything having to do with the individual, other than the fact that he's going to be asked whether or not a particular provision says what the particular provision says. And as you objected or commented while I was examining this witness, I'm getting into a legal issue. This is where they're headed as well.
Your Honor, sir, counsel brought up the whole issue of the well and the interpretation. The statute or the regulation which he approaches and trying to argue to this board is that this applies to this case. That statute, that provision says if you're doing a burrow pit and you're gonna bury, for the protection of public health, safety, and welfare, the use, handling, production, and storage of certain deleterious substances and containments which may impact present and future public potable water supply wells.
Well, before we get to all that, I think Mr. Day's still here before us, and he's been proffered as an expert. The board has not voted on that matter, and I think we need to get that out of the way. Then we can hear your argument and Mr. Bates's objection, and we'll take it from there. Board, Mr. Day's been offered as an expert in natural resources management, or Mr. Day, what are you the?
Yeah. So, the easier way to think of it, I've worked for the county since 1999. I've worked for natural resources since 2000. In my role, I've sat on the DRC committee, so I'm very familiar with regulations and process in terms of the development of property. During that same time, I've been the primary reviewer for impacts to wetlands and listed species, as well as interpretation and regulation of wellheads.
All right. Can we say natural resources management then as a shorthand for all this?
Yes, sir.
All right. All those in favor of Mr. Day being accepted as an expert in natural resources management, could you please raise your right hand?
May I have a motion in a second?
Oh, yeah, that might be handy.
I'll second.
All right, Ms. Smith and Marty. All right, let the record, now we'll vote, okay? Democracy in action here. Okay, let the record reflect that Mr. Day has been accepted as an expert in natural resource management. All right, Mr. Talbot, go with your.
Sir, are you familiar with the application submitted by my client?
Yes, I am.
Okay. And
Could you, Mr. Day, can you get closer to the mic there?
Sorry, I am.
all right. And are you familiar with section 4-5.9 protection area regulation?
Yes, I am.
If there are private wells that are on adjacent properties, is that a forbearance or a strike for the production or approval of a conditional or this regulation to approve?
For the record, I object.
Okay, we have your objection is noted by Mr. Bates. All right, go, Ms. Talbot. You're still on.
Okay. Your understanding is, what is my client, if he has this burrow pit, he's gonna take the sand out, okay? What is your understanding of what he's gonna do with the property afterwards?
My understanding is that it'll be excavated and ultimately become a lake.
Okay. Or is he gonna store any deleterious, toxic, or other contaminants in this pit?
Ms. Talbot, I hate to interrupt, but how is Mr. Day going to know the answer to that?
Okay, well, that's the proposal. The proposal is to make it as a lake. This,
Well, I think you've asked him, Mr. Day's affirmed.
his understanding,
As his understanding that afterwards it will be a lake. Ms. Day, do you know if he's going to store material that is dangerous there? Do you have any knowledge at all of anything like that?
So I don't have any knowledge of it. Part that would, there's two parts, because it's, one, we're still talking about the application of the wellhead ordinance itself. I've done wellheads interpretation and provided comments through DRC on wellheads since 2000.
Right, but do you know?
This is the first time that there's been a suggestion that the wellhead protection ordinance applies to private wells.
Okay, we're not there yet. My question was simple. Do you know, Ms. Talbot has said that that there will be the storage, potentially the storage of toxic materials. Do you know anything about that?
So there's nothing that suggests from what's been proposed that there'll be those items that are on our list.
But you don't know one way or the other, I'm trying
It's
to get.
from the submittal, there's no way to know because at some
All
point,
right,
this actually has to
okay.
go through DRC. And then if something were to be proposed, it would go through a set of
Right.
regulations. It could be county, it could also be the Florida Department of Environmental Protection. So
Okay,
if
but
it's
the answer,
regulated, there would
the
be
short
regulations.
answer is, you don't know.
Absolutely correct. There's insufficient data.
Okay, Mr. Talbot, you next.
What effect does this statute or this regulation have if my client is going to use that as a fishing hole or a pond as part of the reclamation process?
Sorry, can you restate?
Sure. Your understanding, what is your understanding of the Wellhead Protection Act and whether it applies to private wells?
My understanding is that it does not apply to private wells for private use.
And why is that? What's the basis of that understanding?
The understanding is that the entire wellhead ordinance is based on protection of public water supply.
All right. Has that already been interpreted by the director here?
There is an interpretation by Horace Jones.
And is that interpretation consistent with what you just testified to?
It is.
Okay. And when was that interpretation made?
I would have to check a date. I believe it was in 2022.
Was that interpretation appealed in any way?
Not that I'm aware of.
From your y'all's standpoint, is that interpretation final?
It's a better question for Horace, but my understanding is that it would be.
Okay. Now, sir, with regard to the Wellhead Protection Act or the regulation, is it your understanding that that only applies to when you're storing toxic or deleterious materials in the burrow pit?
So it would be, it would be specifically on the property, so it could be theoretically on a side bank. But it's,
So if you're not storing or filling the hole with toxic materials or stuff of that nature, this regulation does not apply to you.
it doesn't apply because it's not applicable with private wells.
And actually, the Wellhead Protection Act defined or identifies it as a public potable wellhead, correct?
Correct. That's what the regulation's intended to protect.
Can this lake, in your opinion, from what you've seen from the proposal, can it be operated, or the burrow pit that's going to subsequently turn into a lake, can it be operated safely on this property?
So, yes.
And what is the basis of that opinion, or can you expound on that?
Unlike a pit that's intended to receive some form of waste in the future, there's no waste that's going to be imported that would add to risk of groundwater contamination.
What if, for instance, it overflows? What would happen? Would the neighbors have a risk of being flooded out?
It's, well, with the creek next door, presumably, once the pit itself would fill up, it would essentially act like a stormwater pond, and then it would discharge downhill to the creek where water presumably currently discharges when it rains.
And as far as buffering, is there ways in which their buffering can be applied in this case to protect any type of residential property or any type of adjacent property owner?
Yes, the LDC does have buffering criteria that's been established by the board.
And is the buffering criteria submitted here wider than what the LDC outlined?
It's, my understanding is at least a portion of it is.
And can trees and fences and so forth and other bushes help to absorb or prevent any dust that's generated from going to adjacent properties?
It's, yeah, natural vegetation is one of the tools that can be utilized. Additionally, there are regulations in place from both the county and DEP regarding offsite dust. And so through the DRC process, we would have a dust mitigation plan that would be approved.
And that will be determined subsequent to this board's decision. If it's approved, then y'all will get involved and verify that the dust suppression system is appropriate and proper.
Yes.
As well, there will be annual inspections of this property to verify and approve that they were actually following the plan, their permit, and not doing anything improper on the property.
So presuming it was approved, my staff would visit somewhere between monthly and quarterly to do particulate marking, which is just dust leaving the site. There would be an annual meeting that also involves planning staff to make sure that they're excavating and meeting all the criteria for the LDC and their development order.
When the staff indicated that they proposed acceptance of this permit and to allow the conditional use, are you part of that staff that agreed to submit this submittal?
It's, at this point, I'm consulting staff as Natural Resources. I'm not a signature on the DRC route list.
Do you have an opinion as to whether this, this burrow pit can meet the criteria for conditional approval and be operated safely?
From my perspective, I don't see any deal breakers on it.
Nothing further, sir.
Mr. Bates?
Mr. Day, would you like to live next to a 40-foot or a
Objection.
44-acre, 60-foot borrow pit within 500 feet of your private well?
I don't object. It's irrelevant whether he wants to live next to it or not.
Ms. Bates, maybe you could rephrase that.
I'm curious because we have a lot of people here that want to talk about having a problem with this borrow pit. I'm asking you, as somebody on this board said last time, do you find a 40-acre plus 60-foot borrow pit to be compatible with a residential use?
Well, sorry. I'm not an expert in that field. You're going to have to refer back to planning for that.
That's what I thought. Thank you. Oh, one other question. Are there any public wells or wellheads north of Bear Park Road?
Absolutely.
I looked on the map and I didn't see that there were any public wells north.
Then I don't know how Century gets their water.
Okay, I don't either. I'm just saying I looked at the map and I found no wellheads north of that. And one last question, what is the definition of a well in the Land Development Code? Just lowercase W-E-L-L.
I do not have it in front of me.
It's not defined, is it?
Objection. He indicated he didn't have it in front of him.
Okay, all right. Are you finished with Mr. State? Before you go, let's just see if the board has questions.
Yes, sir.
Board members, you've heard the testimony of Mr. Day. Do you have any questions for him? All right. I've got one question.
Yes, sir.
We've gone pretty much into the question. As I understand, you spoke about if there is a private well that's within 500 feet of the boundary line for this project, that private portable water well is not covered by regulation. Is that true?
That is correct.
What I heard?
Yes.
Okay. Now, if it were a public well, it would run by a municipality or some kind of government agency, then it.
Or co-op. It needs to be a public potable well. And so I would have to recheck the old definition. It's no longer defined in code. It used to be either serving 15 or 25 people.
Yeah.
It's easy enough to pull the old regulations.
Yeah. And so what we're talking about is there's a difference between, for the purposes of this discussion, between a public well and a private governed well, right?
That is correct.
And I I would like to know one additional thing. Assuming for the sake of argument that there is a private well, or even a public well, it, within 500 feet, it's still, that water quality could be impacted potentially by this kind of development. Isn't that true?
So, that is true. So, an example of that is if you're within the protected wellhead, although a stormwater pond could be placed on the property, they don't allow for a sand chimney, which makes the stormwater go down into the groundwater more quickly.
Right.
So there would be potential limitations associated with a public well and things like borrow pits.
Yeah. And also the effect would be, the well doesn't know if it's public or private. The effect could be in a private well the same, is that right?
It could have the same effect.
So this discussion, well, thank you. Thank you, sir. That's, and I appreciate your testimony. You cleared that up. It seems to me, y'all, the discussion so far about these regulations, if you heard I'm sure you did, Mr. Day's testimony just then, it doesn't matter in one sense whether it's public or private. A well within 500 feet of a development like this can become contaminated. So I'm not sure how the regulation about this, how, I think we've gotten too deep in the weeds about the actual regulation per se. That's just my thought.
We have a lot of people that want to speak. I would like to address your question in a closing argument, if I might.
All right, sir. Mr. Talbot, there's still Mr. Talbot here. Ms. Talbot, do you have an engineer or someone next up?
We have Mr. Patterson's next up.
All right.
Please state your name and address.
Justin Patterson, 1536 Pelican Point Drive, Talbot, Florida.
And
Please.
could you be sworn?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Can you, Mr. Patterson, do you own the property at 5595 Highway 95A?
Yes, sir.
Okay. Is that here in Escambia County?
Yes, sir.
And is the property directly adjacent to Highway 59A?
Yes, sir.
And approximately how much of your property is adjacent to 59A? And I say that with that side, about how much of the side? Length of the road?
Road coverage, I've got 8-9 acres maybe, right in front of the entrance.
And how many total acres of this property do you have?
52.8 acres.
When did you purchase this property?
Back in, I believe it was March of 2020.
Why did you purchase this property?
To put a lake on it and build a house.
And did you, before you bought the property and you said you want to build a lake, can you explain how the process of building the lake?
Well, to build the lake, I have to get a permit to dig the dirt out. I also own another pit in Escambia County. And that's what I do for a living. So, I want to use the dirt to help fund building my house. I mean, that's what anybody would do if they were in my line of work, honestly.
And sir, before you bought this property, did you inquire into the county as to whether you could dig the dirt out and do a burrow pit and then fill it with water?
Yes, sir.
And what was explained to you by the county before you purchased this property?
I was told that it met all criteria, that it was in the right area, had enough acreage, that that the pit would have to be 20 acres or more, and that there would be, no issues with me getting it permitted.
At the time that you purchased the property, there is some property directly adjacent to yours that is owned by Connors Realty LLC. Isn't that correct?
Yes, sir.
And your property, is it owned in your name or LLC?
It's in my name.
And, but the property adjacent to you for which council represents is owned by an LLC, right?
Yes, sir.
Okay. At that time, when you purchased the property, was somebody living in that house?
No, sir.
Was anybody on that property, or was it a vacant piece of property?
It was vacant.
And then Mr. Connors subsequently purchased the property,
Yes, sir.
or his Connors Realty?
Yes, sir.
Okay. Now, sir, your intent is to dig the hole, is that right?
Yes, sir.
And to sell the dirt?
Yes, sir.
And how far down do you dig, or how far are you intending to dig down?
The deal is, and this is what I've went over with the county. Sorry, I'm gonna go overboard with this a little bit, but the reason what I'm permitting is because I've went through this type of stuff before with my other pits that I've ran. Far as me permitting 44 acres, I'm not digging 44 acres. I understand the facts that Mr. Bates saying that nobody wants to live beside a hole that's 40 to 60 foot deep. I get that. I don't either. And I'm building me a house out here. I bought this land. I got my house plans drew up in 2020 before I ever even came to this meeting to get it approved the first time. And I have those plans. I can show them to you. I can show you the check that I wrote to the guy making the house plans. The fact of the matter is, this has been the plan from day one, and there's nothing else happening. If I'm gonna build my house in front of this, why would I leave it a 40 to 60 foot hole? I'm not. I'm still gonna have cows out there. I'm still gonna have livestock. There's gonna be pastures left and all that. The reason of having it 44 acres is to where I don't have to go back and try to get something expanded or whatever if I want to curve the lake or whatever in a certain area or build a pasture a certain way or something like that. This is going to be my residence, and everybody that's here wanting to speak about this, they know only one side of it, because the Connors behind me actually have made
Is this
very
going to be
true.
a narrative, or is it going to be question and answer? I'm a little-
This is facts, sir, and I would appreciate you
Easy,
getting interrupted.
gentlemen, please.
I was used to the question and answer, and now he's just going with the
Yeah.
narrative.
And
That's what's funny, that's
I take it if that's supposed to, you're objecting, then.
Well, sir, I'm sorry, I'm not.
Hold on.
Sir,
I'm the
just
applicant.
hold on. Mr. Talbot, if you'd like to do some,
I'll do some more, help you.
yeah,
Okay.
help him,
Sir.
then I think that would be helpful.
Sir, you indicated, or there's people here to testify. Is your intention to store anything deleterious in this?
No.
Okay, it's to make a lake, is that right?
Yes.
Okay. And has stuff been told to other people here, or have you seen flyers that have been put out by Mr. Connors?
Yes.
Okay, and did they say that you were gonna cause toxic issues to the groundwater and all that?
Yes.
Okay, and that's not what you're intending to do?
No, sir.
correct?
No, sir.
Now, the issue with filling, you mentioned that you do this for a living. You own another pit, is that right?
Yes, sir.
Okay, and with that other pit, do you have any plans, or when it's finished, what is gonna happen with that pit?
That pit also has the reclamation plan of a lake, and I've already discussed it with with the board and everything. It's gonna go before the BCC to be donated to the county, and it's gonna be once it's signed by the BCC, it's going to be donated, and it's gonna be turned into a recreational property for the Wedgewood community, is the plan. It hasn't been signed off on, but that is the plan.
And your plan for this this property is for your personal house and your personal lake, is that right?
Yes, sir.
Okay. Let's talk about a couple of the issues that they bring up in the traffic. All right. Highway 95A is, you've driven down that numerous times, right?
Yes, sir.
Does commercial traffic use that property? Or
Yes,
use
sir.
that street?
Yes, sir.
Do you see dump trucks on that street on a regular occasion?
Yes, sir.
And if you sell your dirt, is that gonna necessarily create more traffic?
No, sir.
Are there other pits in the northeast part of the county?
Yes, sir.
Where are those pits in the northeast part of the county?
There's one off of Cemetery, I believe it's Cemetery Road, way north of me on Highway 29. There's one across Highway 29 off of 97. The traffic that's already going through there are going to those pits right now.
If there's development, is there development in the area?
Yes, sir.
Okay. And builders will have to buy dirt, is that right?
Correct.
And if you don't have a pit, where would be the quickest place that they could buy dirt?
Cemetery Road, at the Campbell's Pit up on Highway 29, north of me.
How far north of you is that?
To be totally honest with you, I don't know the exact mileage. I've never been there. I believe it's probably another 7 or 8 miles, maybe.
And would
past
your
me.
pit essentially take business away from people buying dirt from his pit?
Possibly, yes, sir.
And if people buy from you, would that relieve some of the commercial traffic that would have to go north on 95A to get other pits?
Yes, sir.
I suggest we're getting very far afield as you accused me previously.
Yes,
So
I think we are. I was almost there. I was gonna try to give you some latitude, but,
And that's all I was establishing, and, because they're bringing up traffic in commercial use, and that's what we were developing, so.
well, if it will help everyone's mind on that, traffic is one of those things that the board really is not, that's a bailiwick that we aren't in. That would be decided by the DRC. So generally, we can observe that there is traffic on the road, on the highway. It is made up of many kinds of vehicles, including dump trucks. There are many sites, or several sites, for borrow pits on the highway, on that highway, and trucks go from here to there.
Yes.
I think that pretty much settles,
Yes, sir.
or sets it out. So, but that's not gonna be a real factor about where we are.
Yes, sir. Let's talk about whether the property can be conducted in a manner that is consistent with the area. Do you feel that you're able to conduct or operate on this property and dig the dirt out of the ground in consistent with the what's going on in the area?
Yes, sir.
Okay. Can you explain to the board why?
Well, there's use for the dirt right now, and with subdivisions being built around me, and like I said, it's all about honestly it meeting the 5 criteria. It meets them.
Okay. And sir, with regard to that, you said you're not going to put any type of deleterious or toxic items, right?
No, sir.
Okay. Now, what about, was this property previously, do you recall some testimony from a neighbor that said she previously followed somebody dumping on this property?
Yes, sir.
So did somebody previously use this property to dump some dirt or tree type waste?
They were actually digging dirt in the back and threw a few, threw some lumber and tin and stuff like that back there in the hole, yeah.
So,
Mr. Godwin, once again, we have a room full of people, some of whom have already had to leave, and this is not pertaining to the application.
It is perfectly complained to the application because it goes to show the prior use of this property had been dug and stuff buried in it, and he is actually gonna clean the property up, so it's improve the area from what is already there.
That's true.
Well, I think you've made your point on that then.
Okay, that's fine.
If we could move on.
Yes, sir. Now, with regard to the property, the buffering in the sand, what are you gonna plan to do to try to protect from the neighbors any type of sand or any type of dust or so forth?
I'm gonna have water trucks, sprinklers on side roads or whatever, but still, that's something we can go over with the DRC.
Okay, you plan to put trees up to make sure that
Yes.
it's all protected?
Yes,
And
sir.
those are trees that would be tall and full of brush?
Yes, sir.
And are you gonna work that out with the DRC about what they propose to protect the neighbors?
Yes, sir. I won't have a choice. I will have to comply with them.
Now, you said sprinklers. Tell me about that. What does that do?
Just knocks down dust, keeps the dust from getting in the air.
All right. And what about noise? You're talking about some dump trucks and come in and out occasionally and the tractors?
It's gonna be, the noise will be minimal. Honestly, it's not gonna be like what people think. There's not gonna be any more noise than there already is there. I put it that way.
Do people operate tractors around the
Yes.
property where you're at?
Yes, sir.
Okay, so if somebody's operating a tractor and you're operating an excavator or truck, it's gonna be similar to activities around there, is that fair to say?
Yes, sir.
Similar noise around there?
Yes, sir.
Now, you have two neighbors within, I guess, main neighbors within 1,000 feet. The Connors, have you determined how far their house is off of Highway 95A?
I believe it is 1,200 and something feet.
Okay, and what about your other neighbor?
I believe it's like 900 and something,
Okay.
close
so-
to 1,000.
So both the Connors and the other neighbor are almost 1,000 feet off the road, their house?
Right.
Okay. Now, sir, sorry, I'm scanning to make sure we did some things. Sir, the Dorches, have you ever spoke to Ms. Dorch about this property?
Yes, sir.
Okay, and, did you, tell her what you were gonna do with the property?
Yes, sir.
Okay, and you told her you were gonna build a lake?
Yes, sir.
And what did she say in response to that?
The first time I met her, she said that she didn't care what I did. It was my land, that I ought to be able to do what I wanted to on my own land.
And are ponds common in this area where you're at?
Yes, sir.
Okay. In fact, doesn't Ms. Dorch have a pond?
Yes.
As far as public services, you're not gonna require anything more of public services? Like, power and water, anything extensive?
No, sir. Nothing other than what I have now.
All right, as far as getting into your property, the ingress and egress, are they able to just turn off 95A?
Yes, sir.
And you're gonna have a wide enough driveway there that they can turn in?
Yes.
Are you gonna have signs, any type of lit signs or anything of that nature?
No, sir.
Just, what type of sign do you plan to have?
Just whatever the county requires me to have.
Okay. Nothing further, sir.
Ms. Bates, did you have questions?
I did have a question too, yes, sir. Mr. Patterson, your application says the subject property is largely surrounded by undeveloped property. There is one residential structure to the south of the proposed site, period. Is that accurate?
Yes, sir, it was when we done all that. Yes, sir.
This application was submitted this year. Is it correct? There's a whole lot more than one residential property around this site, isn't there?
There's, yeah, there's more than one. Yes,
So
sir.
your application in that sense is not correct?
Right, yep.
Okay. And were you telling this board that you're going to you're going to plant mature trees as a buffer?
Yes, sir. Yes, sir. Well, there's already plenty of trees out there. The only place that needs to be a buffer would be on the northwest end of my property, which I don't understand why anybody would want a buffer for what it's gonna look like at the end, but
How long do you intend to operate the pit?
that, like Mr. Homer said earlier, that depends on what the housing market does.
So it could be a year, it could be 10 years, you don't know?
No, sir.
Okay. Real quick, with respect to I had the question on my mind and it slipped away. You're talking about installing a pond, but what you're doing is actually talking about converting a borrow pit to a pond down the road someday, right?
No, sir. What I'm doing is, like I said, you're getting off topic again. See, that goes. Let me finish, sir.
Gentlemen,
That is
Ms.
determined
Patterson.
at the BCC meeting.
Ms. Patterson,
I'm sorry.
just answer the question.
Well, I can't answer if he, it's not an answer that I can make because the BCC has to determine all that. That's the reclamation plan. We've already went over that.
Okay, well,
multiple times.
you have answered his question then.
Right.
Who's the applicant, Iron Horse or you?
The applicant is Iron Horse
And
for the pit.
Okay, your Iron Horse LLC is the applicant.
I am not an LLC anymore. I'm an S corp.
Okay, Iron Horse Incorporated,
Yeah.
an S corp. Okay, and you said you're involved in another borrow pit. Is that Shortleaf LLC?
Yes, sir.
And Shortleaf LLC is the borrow pit up by the Wedgewood community?
Yes, sir.
It's had a lot of press in the recent past?
Yes, that had nothing to do with me.
And are you a manager of Shortleaf LLC?
I'm the owner.
You're the owner, and you're also the manager?
Yes, sir.
Okay. Is that part of the experience that you're touting for purposes of your application to this board?
I don't understand what you're asking.
Who is going to be, no, I don't have any more questions.
All right. Or do we have any questions for Mr. Patterson?
I'm sorry.
Ms. Patterson, I do have one. Do you have any idea how many homes would be involved if your project was completed or we granted approval, I guess is what I'm trying to say. I've heard one, I've heard two. Do you have any idea of how many homes would be touched by this?
To be totally honest with you, sir, it's not gonna affect any of them. Yes, they'll see a dump truck coming in and out or whatever, but there's already dump trucks coming in and out of the house next door to me. They're saying, and I'm not trying to be.
Yeah.
I'm just saying it's the deal is it's not gonna be like everybody thinks it is. The reason they think it's going to be this way is because people have made them think that.
Yeah.
There's 3 houses right there beside me that would be in, that could actually see it, is all I know.
Okay. And so there are several homes that are around.
There's one to the northwest of me, and then there's one to the northeast of me, which has no issue with it. I've already spoke with them. And the other two people that live there didn't have an issue with it until Mr. Connors and his attorney went to his house, to their house, and made it an issue.
Okay.
Can anybody help to put the map up so you can? Put the map up.
Yeah, let's take a look at the map. All right.
If I may, show?
Yes, sir.
Okay, if you look at the bottom, the south part, where the residence you talked about, the Connor property, where is it located? Is it the bottom of your south part of your property?
Yeah.
Okay.
East corner there.
All right, the Dorches, are they in the top right of your property, the
No.
west corner?
No, sir, they're at the top left right
Yeah,
there.
that's what I'm sorry, the top left, the northwest corner, I'm sorry. And that's one where you can see the pond on their property too.
Yes, sir.
Okay, and the other house that you said where is it?
It's right there on the northeast corner of where it comes back out and makes the long line north. It's right there, that little small lot right there.
Up top
Up.
of the,
Two, right there. That's Mr. Glass.
all right, and he was okay with it?
Yeah, he has no issues with it.
All right, now, if we could go down to the southeast corner of the property, there's a large, right in that area.
Yes,
That is a agricultural area, or there's nothing but trees there?
that's just a vacant piece of property.
And
yes.
that's gonna separate, that's not your property, is it?
No, sir.
Okay, and that separates as another buffer between your property and Highway 95A.
Right.
And on the bottom right-hand side, you have more trees. That's gonna, with that buffer between your property and the Connors property?
Yes, sir.
Okay. And sir, your house is gonna go where on this chart?
Right where my barn is now.
Right there?
Yes, sir.
You mentioned that a neighbor has dump trucks, is that right, coming in and out?
Yes.
Where's that on the property?
Right on the edge of my property, the north side of my property.
Okay, the top north side, so
Yes.
in that area, there's dump trucks going in and out there?
Yes, every once in a while, yes.
Okay, and is there other items that is being put on the property right there on the north side of your property?
Actually hauling dirt in and gravel and mulch and stuff like that and putting it back there, yes, sir.
Are they also burning anything on that property?
Yes, sir.
All right, who owns that property?
I'm not, I believe it would be Dale Kite, or I don't remember his wife's name.
Okay.
It'd be the Kites,
All right,
the daughter of Miss Dortch.
Okay, so Miss Dortch, who's probably is here to state, it's her daughter-in-law that owns that property?
Yes.
And who is
Mr.
the
Goggin,
person?
we're gonna be here all day.
We may be, if you have to
Well,
keep interrupting.
Mr. Bates, you did kind of open the door on this when you asked Mr. Patterson how many people live in the vicinity, so I think it's only.
Testimony has been gone far beyond that, and whether or not Ms. Dortch is related to somebody who might own the property down the street is wasting everybody's time.
No, sir, what the issue is if she's here to testify to object to his digging a pit, her grandson is operating dump trucks, storing dirt on the property directly adjacent to her, burning trash on the property adjacent to her.
Well,
So
now, Mr. Talbot, I think we are getting up.
But
My question was simple. I just wanted to know how many homes are around, and I think Mr. Patterson has answered the question the best he could.
Yes, sir.
So these other matters aren't germane to where we are, so.
I think the only purpose of that was just to let people know that it's not gonna affect anybody around me any more than what's already being done at the
Okay.
same piece of property already.
All right, sir. I appreciate your statement.
Yes, sir.
Thank you for your testimony. All right, Mr. Talbot, do you have anyone else that you'd like to,
Nobody else, sir.
nobody else? Mr. Bates, do you
I
have?
My client and I have my engineer, but at the same time, we have a room full of people that haven't written off the day who would like to speak. I would like to let them speak their 3 minutes or whatever you all allow, and then defer my witnesses till they're done, if that's okay. I'm just trying to accommodate the group.
He needs to present his testimony, sir. He wanted to step up and wanted to defend his client. Step up and let's present the witnesses so that we can get through them.
Well, Mr. Bates does have a good point. I know that this has been a long proceeding, and I know that all the people who have taken time out of their day to come have things to do and responsibilities elsewhere.
Mr. Chairman?
Yes, sir.
Even though I'm not voting, I would like to add, piggyback on that. These taxpaying citizens, they have came out today to voice their opinion, and I think their voice need to be heard, because everybody, they don't own businesses, and they don't have the flexibility the way we do at times, and so I think it'll be good if we hear from the community at this point.
Well, board members, gentlemen, would you like to hear our speakers? We can go ahead and go through our list here. Mr. Bates, though, realize though once we go through these, it's the board's prerogative and their decision. We're pretty much going to go to try to bring this to a conclusion.
Well, in all due respect, Mr. Godwin, I have 2 witnesses that I'd like to present, but they can be here and there will be here. I'm trying to accommodate this group of people. If you're telling me I can't put on my 2 witnesses, if we let them testify, then I've got to go.
Well, I'm just telling you that once we get to that point, we will want to begin to bring this to a conclusion, so.
I've got no choice but to call my next witness.
But I agree with
understand why
you.
that couldn't be.
Mr. Bates.
I'm so sorry. I interrupted and I shouldn't.
Yes, sir. I'm doing my very best to accommodate you on this, and I would be helpful, I think, if you would please allow me to try to do that. So what we're going to do is this. We're going to hear from the public, which I and the board appreciates, have sat here through a long morning. And then when we finish with the public, we are going to be entering into the conclusion to this hearing. And at that point, if you would like to offer your witnesses, if the board would like to hear them, I don't have any objection to that. But like I said, I would appreciate it now if you would let me try to move this thing along, because it has been a long morning, and these, I agree with you, these citizens have waited a long time, and we're going to accommodate them. So
Again, I have 2 witnesses that I will.
yes, sir, I understand, and it's on the record.
Thank you, sir.
All right. Mr. Talbot, he definitely has spoken. Do we have the clock, Madam Clerk? We will be allowing each person 3 minutes from the general public to voice their opinion. And as I said in the beginning, if your neighbor says something and that's pretty much where you are, then you can just say, he said it, And that will allow things to move along even quicker. But by no regards is anyone going to be denied their time. So, and again, thank you. We begin now with Dawn, and, oh, if I butcher your name, which I will, please forgive me and correct me. I'm sorry. So I say that ahead of time. Dawn Osler?
Hollister?
Yeah, that must be it.
If it's all right with the board, I would be happy to defer my time until everyone else has been heard, because I do have the flexibility to be here.
I'm sorry, I didn't hear you, ma'am.
I would be happy to defer my opinion until after everyone else has been heard, because I do have the flexibility to be here. I'm not pressed to be anywhere else.
Okay, all right, that's very good of you, ma'am, and I'll be sure that you will get your time. Anthony, well, we heard from Mr. Patterson, so we don't have a problem there. And of course, we've heard from Mr. Bates. Jim Connors.
That's my client, Your Honor. He will testify. He's one of my witnesses later.
All right, well, we will look forward to that. Sharon Kite.
Please raise
Thank
your
you,
right
ma'am. Thank you for waiting.
Oh, yes.
Could you give your name and address and allow the clerk to swear you in?
Yes, my name is Sharon Kite. I live at 5537 Highway 95A.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, so my main concern is I own a private well that, according to, I don't remember your name. Mr. Jones has, during we had our break, told me he couldn't tell me when private wells were required to be permitted, nor when they were required to be documented in Escambia County. I know that my private well, Ms. Storch's private well, Mr. Connor's private well, were all installed within a maybe 5-year window. My concern is that whenever he starts digging, that the water table there is between 6 and 24 feet. And if he goes past 24 feet, when he gets down to 55 feet, as his previous pit is, that he's said he was going to donate, he's going to hit an aquifer. And that concerns me, that the aquifer would be disturbed and affect the water tables. Okay? As far as the pit that was there before, the person who owned the pit that he bought it from, Vicki Henderson, she actually owned his property and she owned Mr. Connor's property. Okay? So the lady owned that. She bought the property that I just drew a blank. Patterson, thank you. I just drew a blank. Sorry. That Mr. Patterson bought to stop the pit because the person that was there was illegally dumping. Okay, that's why she bought it. She lived in Birmingham and she sold it. But, you know, what is the time period? What is temporary? How long is temporary? And how long, will there be an extension? Once he digs a pit, will there be an extension to it? And if so, how long will it go on? I know people said it's up to the market. Well, with something like this, if you're planning your residence, then maybe start building a house and allowing your neighbors to see that you're wanting to build a house there. I mean, I think that's really a big concern. I'm sorry.
No, sir, not at this point.
I know, but I'm just saying the aquifer is my main concern and the wellheads. Thank you.
Ma'am, but before you go, first, I've got a question, and then these gentlemen may have questions for you. Your first question is, where is your well?
I live on the other side of the pond, that next section over. The other yellow section right from the pond. Yeah, I don't do directions, yes.
Okay, and how do you know that the aquifer is?
Because that's what the guy who drilled the
How
well
deep
told
it-
me.
How
I
deep?
mean, I don't, he's no expert at all. Not certified, not qualified, or anything.
But I'm just curious how you knew, learned that it was like
Just a little
24
research,
feet.
that's what he told me, and I went with his word.
And, okay. All right, well, thank you, gentlemen.
And somebody may can speak to that, I don't know. I mean, I'm just going by what I was told.
How long have you lived in this property?
34 years.
Okay. And how do you know when the property, the well on the Connors property was put in?
Because the gentleman that installed it installed my well also.
Okay, so that's hearsay. You don't know, you have no personal knowledge. Is that
Of what?
Of when it was installed.
Oh, it was installed in the 90s, early 90s.
You have no personal knowledge, that you weren't there to watch it. Personal knowledge means that you
I don't have
saw
any
it.
pictures of it, yes, no.
Ma'am, you're related to Miss Doris.
She doesn't know, Mr.
Yes, I am
Ms.
her daughter.
Talbot. She doesn't know.
I don't know.
So I think that's the answer. Nick,
My only
another
concern
question?
was the water tank.
Ma'am, you're Ms. Dorothy's daughter, correct?
I am.
Okay, and your grandson, does he operate a?
He does.
Okay.
He has a, go ahead.
Okay. Does your grandson operate a dump truck on your property?
My son,
Son.
not my grandson, my son
Okay,
has started a private business, yes.
yes, ma'am. Just a moment.
My 3
Mr.
minutes are
Bates,
up.
what,
I guess I didn't anticipate that each of the several commentaries from the public for their 3 minutes would be subject to cross-examination
Nor did the
beyond
public.
3 minutes.
Our rules, it's the rules, read the rules he quoted earlier.
yes, sir. It's, in theory, they are. Most often, in cases they're not, the witnesses, or the individuals who speak are not. Generally, they voice their thoughts, and that's pretty much it. But this is a different kind of situation. You gentlemen have the right. If you want to exercise it, then you're entitled to.
Okay, now ma'am, you said your son operates a dump truck and has a business on that piece of property directly north
He
of my.
stores his equipment there.
Stores, okay. Does he have a dump truck he drives on that property?
He does have a dump truck.
Does he have dirt piled up on that property?
He has had.
Is he selling dirt or gravel from that property?
Mr. Talbot,
No, that's for personal use.
we've
of
got,
the- Can we please?
we're going to be here a long, long time. If, this is far afield to what we're
concern
doing here.
It's with the water.
Sir, if I may, okay, I want to make the record that one of the factors for which they address is whether the property can be operated in the same manner
He's not
as
digging.
adjacent level properties.
He is
And
not
that, excuse me,
digging.
ma'am, okay? And the issue here is if the property directly north of her and one of the people complaining is operating the business, driving dump trucks, storing their dump trucks, and selling dirt and gravel from that property and transporting it, it is gonna be the same operation. So my client using to dig a hole and sell dirt is
Well-
consistent.
Well, that may be argument for a closing, but it's not where we are right now.
I'm
If-
not trying to argue now, sir. I was trying to present testimony on the record.
Oh, okay, I think you've accomplished your mission there. I take it no more questions. Thank you, ma'am. I appreciate you coming. Our next speaker, Randy Woods. Mr. Woods, if you could face the clerk and give your name and address and also be sworn.
Okay. Randy Wood, 1451 Rolling Oaks Drive, Molina, Florida.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
Okay, I just wanted to make a couple of points because we're talking about an agricultural zone. Molino is changing so rapidly that the agricultural zone is
disappearing rapidly. We've had like 4 new businesses come in, and one is a proposal for a Circle K at Highway 95 and Quintet Road. We've had 2 at the end of 196 and 29, Cozy Corner Parking Latte Coffee Shop. And we've had a Dollar General come in, 29, 196. Molino Fire Department just announced the other day, we went from a volunteer fire department to a full-time fire department because of the residential increase in our area with new subdivisions. We've actually had a proposal for 6 new subdivisions that are currently going in the area with an anticipated residents of 3,956 new residents. And of course, that would equate to, based on 2 cars, about 989 new cars on the road, driving every day. And that's a lot of homes. And that's excluding the one that wanted to go in at Woodland Park, the development. It was 2,356 townhomes, 265 single lot homes. That was postponed, but they pulled it back out. But they will be trying again. These are going to be coming in. So this area, as far as agriculture, is rapidly changing drastically. So what was an agricultural area is no more. You don't see big cattle farms. You don't see any of that stuff out there. This thing is changing. They have nowhere else to go but north. Everybody's moving north. There's nowhere to build around here. So they're going north, and the whole environment's changing. So as far as agriculture, there's like a few slots out there, but the things are changing. We have more residents to accommodate, and it just should be a good environment. And then as far as the Escambia County Comprehensive Plan, I had a comment in here in section 1.03 intent. The plan is to provide orderly growth management for those areas identified in section 102. The ordinance is not intended to terminate growth, but rather to provide mechanism for growth management in order to serve the citizens, visitors, and property owners of Escambia County. Okay, the implementation of this ordinance is designed to maintain and improve the quality of life for all citizens of the county. I can't see where this is going to improve my life in the county, in the area where I live. I live right down from it on Rolling Oaks. So, the way it's sloped, the land, it comes down to the creek and then it runs off. It actually crosses the road. I see it as an environmental hazard.
Okay.
It's not good.
Thank you. Thank you for your thoughts, and thank you for coming, and thank you for staying.
So naturally, I'm against it.
Yes, sir. Gentlemen, I take it no questions from this?
No, sir.
No questions from the board? Let's see. Teresa Holleran? Yes, ma'am. I did it. Bear with me. Could you please face the clerk, please?
Teresa Keener Horan, 6950 Kansas Road, McDavid, Florida, 32568.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Can you bring up the photo of the 500-foot perimeter that was placed on there? So my understanding is that we're here because of a proposal to put a burrow pit within 1,000 feet of a residence. This only is half of the perimeter that's needed to actually represent the amount of homes that are going to be impacted by this burrow pit. There are many, which has already been stated, but there are many undocumented wells, which again is a question of when were they required to be documented. And the reason that I'm here, because my address is clearly not here, but I am the daughter of one of those affected. Sorry, I'm a nervous public speaker. But this is this is a family legacy. So my children will probably live in this home. My children's children, hopefully it goes on down the line. This property was bought with money from my grandfather. So I would just like to see residential use or agricultural use, not borrow pits in this vicinity. We have a very tight-knit community. I've probably grown up with most of these people's children, because you see it's a much older generation in here. My children are friends with some of their grandchildren and some of their children. We want our community to grow in a positive way. He's basically stating that he's going to come in and build a home at a lake. I don't see any movement forward to accomplish those goals. I'm familiar with the Kites, the Dorches, their son that he is referring to as running a business off of their property is incorrect. He's actually building his home and his business across the street from my current property. So we are neighbors. I buy dirt from him and I see where it comes from across the street from my house. I don't think that this borrow pit is going to be a lake. I don't think that he is going to build a home, and I haven't seen anything other than his just simple statement and testimony to that fact that indicates he is intending. He already has stated up here as well that he has no intention of running any more power or water to the property than what is already there. To my knowledge, in order to build a home, power, things like that are going to be needed. I think us as a community are tired of aggressive behavior from the gentleman. He already displayed it in here multiple times. There are a lot of gunshots going off from that area, hog pens being built. It's aggressive, and it's not
Okay.
appreciated.
Thank you, ma'am. Thank you for staying.
Mr. Chairman? Mr. Chairman?
Yes.
I have a quick question for, exactly where is, your property located, from this property? And, so basically,
No, it's fine right there.
so
But,
bas-
so if you take his property, his bottom of that property line, go straight to the left. All those little bitty squares down there are residential properties. My father's property is the very top one in the little yellow squares. Yes.
okay.
So if you expand that out to 1,000 feet, if it's, proportionate, that's going to include my father's land as well as his well that he uses as potable water for himself, not horses, not animals. That's what he drinks from.
So is that the property where you, currently, buy
I
dirt
do
from
not-
across the road?
No.
Okay.
I currently live in Walnut Hill.
Okay.
I'm an only child. This is my family property. That's the property I grew up on. So that is 100% coming down the line. That will be my property at some point.
Okay, I just wanted to clarify that because I didn't want anybody, for you to sit down and they think that you're buying dirt from across the road from
Right.
this property we're speaking of. I appreciate it.
Okay, if I can, on that same thing, you said you're buying dirt from Miss Kite's son, right?
Yes.
And you said he's building his house there, right?
From my house in Walnut Hill.
Okay, but where you're buying the dirt from is the property north of my client?
No, he is getting the dirt from across the street where he is building his home in
Across the
Walnut
street
Hill.
from where?
In Walnut Hill.
So he's digging dirt? Hold on, so he is digging dirt and selling it to you?
He's not digging dirt on his property. He has his dirt stored on his property.
Where does he get the dirt from?
It comes from a pit from his cousin,
Who's his cousin?
the guy that runs the dumpster.
Who's the cousin?
Why does that matter?
You're the one that's saying it.
Well, I think we're getting a feel here again. I think she's answered what you've asked, so. if
And that was
there's
the
a
reason
new
for my-
topic, let me know.
That was the reason for my question, Mr. Chairman. I didn't want anybody to be, confused about where she's getting the dirt from. And I just wanted her to clarify that she wasn't getting the dirt across from this property, that we're speaking of today.
Well,
because it was
yes, sir,
mentioned that it was
I
coming
think
from-
we've established that.
Yes, I agree.
Thank you, ma'am. We appreciate it. Eulala Travis? Yes, ma'am. Thank you for coming, Ms. Travis.
Thank you for being here too. For me being here.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
That's true.
Thank you. Please state your name and address.
My name is Yola Mae Travis. My birthday November 6, 1942. And that road y'all call 95A was 29 when I was born.
Yes, ma'am. And your address for the record, too, ma'am.
876 Josh Lane. I stay right in front of Patterson property he bought.
All right.
But I remember when it was hay, but ain't nothing over there but rattlesnakes.
All right. Thank you, ma'am. Now, what would you like to tell us?
I'm against that pit he's gonna build there, 'cause my house is right down that road where it says Josh Lane. My box number is 876.
Yes, ma'am. Do you have a well, ma'am?
I has 2 springs on my land.
I'm sorry, I didn't hear you.
2 springs. They was there when I stayed on Cedartown Road where I was born at.
Yes, ma'am.
That's about a block from where that road, Josh Lane, is to Cedartown Road. Go like this way, go through Molina.
Yes,
But
ma'am.
anyway, it wasn't no houses up there then. And I used to stay in, it was an old house made like an L. You go across that field, back down there where I stay at now. They used to wash back there. You know, the people's on the rowboat.
Yeah.
And the tubs back there, and there's 2 springs back there. It's one, when you go down Josh Lane, you go around the curve like that, it's one water running there. And I deed my daughter a half-acre land. She got a house built there. And on the other side of that, it's a spring go down there and go around through. I know him as Calvin, his fish ponds.
Yes, ma'am. And that's what you use for your water supply?
Nope, I got city water, Molina.
Oh, okay. Thank you, ma'am.
Thank you too.
Joshua Lowry? Oh, thank you, sir.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name and address, please.
My name's Joshua Lowry. I live at 5730 Highway 95A, Molino, Florida.
Yes, sir. What would you like to tell us?
I'm against this borrow pit. I've got 3 young daughters, and just here at the top of that 500-yard range is where my daughter's bus stops are. I've got 2, one in middle school, one in high school, and a third one about to go into middle school. There's been 2 traffic fatalities within that same range right there. The young lady, well, the older lady who owned the property before me was killed on that road checking her mail. And the motorcyclist was killed right across from Cedartown Road. There's already enough traffic on that highway, and I understand there's construction and growth, but adding a borrow pit right here is going to centralize that traffic within the range that I live. Right? So trucks coming in and out of there, essentially almost adjacent to his properties, that church where the school bus stop is. So they have to walk from my house to that school bus stop. And it makes me worried that all this extra construction traffic might take the life of one of my children. I don't have a local well. It's anecdotal evidence, but if you dig 2 feet down in my backyard, you're hitting water. So I can't say that there's an aquifer there, but there's water within feet of the ground level within 1,000 yards of that property. So I understand that Mr. Patterson might be trying to, make some money, and I'm not against somebody trying to make money. I just don't want it in my neighborhood. This is where I live. This is where I'm raising my family, and I just don't want it. I mean, it just comes down to that. So that's all I have to say.
Thank you, sir. Thank you for coming.
Yep.
Rebecca Dorich. Gentlemen, by your silence, I'm assuming that you have no questions. If you have questions, please speak up. I'm not going to say every time questions, so just be aware. Thank you, ma'am. Thank you for coming. Could you face the clerk and raise your right hand.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. State your name and address, please.
I am here in reference to the dirt pit that's going in my yard, and some corrections to what Mr. Attorney had to say that Mr. Patterson said about me.
Yes, ma'am. Could we have your name and address
My
first?
name is Rebecca Dorch. I'm at 5525 Highway 95A North.
Thank you, ma'am.
I did speak with Mr. Patterson. He stayed about 3 hours at my house one day, telling me what he was going to do, and that I did not need to come to a meeting because he had everything under control. I told him I didn't have a problem with him digging a hole and having a pond, but I also told him that he could only do what the county would permit him to do. That was to build a dirt pit within 1,000 feet of a residence. He was in the area before he bought his property, so he knew where most of the houses were because he was down my driveway with Mr. Devine. So, one thing people are not saying is this pit location is 1 mile south of the county complex in Molina. Also, my water well is 143 feet from the property line. My house is 121 feet from the property line. So 1,000 feet is a long way. As I was leaving this meeting, April the 20th of 2022, I was on my way to my car, and someone came across the parking lot and met me and asked if I was Mrs. Dorch. And I said, yes. And I said, well, you must be Tracy, because I'd never seen her before other than at a distance. And she identified herself as Tracy.
I'm gonna object.
She
You know, this is
told
going
me
off
that
base.
she was going to make,
She's going off base, you know.
Well,
She has,
she told me
she has
that
3
I had
minutes,
seen
though.
all the green, that I was
Ms.
going.
Ms. Dorch, hold it just a moment. What is your objection?
She might have 3 minutes. However, we don't need to get into this either name calling or those other issues.
You've already name called, sir.
Ma'am, just hold for a moment, please. Ms. Dorch, what's the substance? How is this related to what we're discussing today?
What we were discussing today, she told me she was going to put up a 10-foot for privacy fence and told me I was not going to see any green anymore. And when she turned around to leave, she turned around and told me she was going to make my life as miserable as hell the rest of my life. I'm 82 years old, so I feel like that my life has been threatened.
Yes, ma'am. I understand that.
Okay, that's,
It might help if you told them who Tracy is.
pardon?
Who is Tracy?
And see, that's the whole thing. I mean, that's the.
Tracy Majors is Mr. Patterson's office administrator.
Okay. All right, Ms. Dorch, I understand that. That's really not relevant to where we are. That's
understand
kind of, well, it's just not relevant to our
Okay.
discussion.
My pond that I have at my house, it goes from 3 foot to 9 foot deep, and it's almost 1/3 of an acre, so it's not very big in comparison to 44 acres.
Yes, ma'am. One last thing, Ms. Dorch. How do you know that your house, I believe you said, was 143 feet from the boundary line, the property line? Did you measure? I'm just asking, did you measure it?
I personally measured it myself with a 100-foot measuring tape.
Okay, and the other, and your well was what now?
My well is 143.
I'm sorry, I didn't hear you.
143.
Okay, but these are something that you did yourself?
Yes, sir.
Okay, thank you.
And when Mr. Patterson had his land surveyed, the surveyors was on my property setting up their equipment because they didn't want to go down into the woods.
Okay. Gentlemen, do you have a question that is not, that's germane more to where we are, this question, and not into personalities and, that sort of thing.
I have
Just-
some questions, sir.
All right,
Sir, ma'am, you referenced your well, you have public water though too, correct?
I do have public water, and I have my water in my well is potable.
Okay. And, ma'am, at the 2021 hearing, I remember watching the video, and you indicated that you like to look out your backyard and you want to see the greenery or a lake, but not a hole. Is that right?
I don't have a problem with cows out there. I don't have a problem with the green out there. I just don't want a hole 70 feet deep out there for kids to get into.
And if there was, well, and if, for kids, if there's fences and buffers, you wouldn't see the hole necessarily, would you?
I'm afraid I would.
Okay, you would? So you would see over a 10-foot fence?
Well, so in some places, yes, sir, I
Okay,
can.
all right. And you would agree, my client told you he was gonna build his house there, right?
He told me he was gonna build a house.
Okay, and actually, the area where he says he's gonna build the house is very close to your house, isn't it?
Well, the picture I saw was that he was gonna build a house out between his barn and the Highway 95A.
Right, and the barn is the white, right where the corner where it goes up, that's the white barn, right?
Yeah,
Okay, and he's gonna turn the area of the barn, and he's gonna build a house in that area, right?
he told me he was gonna build a house out in front of the barn.
And, so ma'am, you don't have, so your issue is what, the concern of your well, or what?
My concern is a pit with county code saying that it's 1,000 feet from the residence to bar a pit.
Where did
And
you get that
until,
information? Was that from a council right here at the other table?
it's on this card right here, sir.
Okay, the issue of the 1,000, the card references that 1,000 feet.
I read the county website every week to see what's going on, and I have read the codes pretty regular to know a little bit.
Did you read the code after meeting with, counsel for Mr. Connors?
No, sir.
Okay.
I read it long before then. I've been in Escambia County for 64 years, and I have read the code for several years. Mr. Connor came to my house, but Mr. Connor did not influence what I have to say or what I've done.
Okay, and you don't have a problem with the, dump trucks there, do you?
My grandson has dump trucks.
Right, so, and he has dirt piled up on his property, right?
He does have dirt piled on his property, but he does not have a hole. He has dirt, he brings in dirt, but he
Okay.
does not have a hole that he has dug to dig dirt out of.
Did you put that pond in your property?
I did.
How did you dig the dirt out?
I hired someone to do it.
And they dug the
Mr.
He brought
Mr.
in a,
That's fine.
Yeah, well, this is not going where we are getting far, far afield again. We're just far afield. I don't think this is relevant to what we're here to discuss. And, if you have anything that's not related to that line of questioning, I'd be glad for you to continue, but if not, then I think we've pretty much heard this testimony more than once.
can I say one other thing? Mr. Patterson goes out and plows his field. He has a big John Deere tractor with a triple disc on it.
Yes,
And
ma'am.
he gets out plowing sometimes, and you can't even see the tractor for the dust.
Yes, ma'am. Well, thank you. Thank you for,
But then I live in the country and I love it, but I cannot open my windows because of the dust.
yes, ma'am. Thank you very much.
Thank you.
Yes, ma'am. Paul Alexander. Is Mr. Alexander with, oh, there he is. Thank you for coming, Mr. Alexander.
Well, I should have brought my sleeping bag.
Please
Yeah.
raise your right hand. Do you
Paul Alexander, 5050 Shag Road, Molino, Florida.
do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go.
Boy, 3 minutes, I don't know. First of all, on the wetlands there, on his application, he said he's surrounded by undeveloped land. All that on the west side is almost wetland. It is all wetlands. That's the upper part of Jack Branch Creek, which is underneath the federal Clean Act law. That creek goes all the way down into the Perdido River, out into the Gulf. So we need to have a federal Clean Act person in here to verify that's not gonna affect that creek, which I know it's going to. The lady that, if you'll go back to the 500 radius map, lower left-hand corner where it says RR, go down 3 lots, the big lot. You know, go down to that big lot, right there, that's mine. I've got a well. I'm within 1,000 feet. My biggest question is gonna be, when he goes down deep enough, is he gonna interfere with the radon gas? That's the biggest question as far as that, and is it gonna interfere with our wells? My neighbor to the north of me, the one with the orange hat, Joseph Bell, I'm his Social Security benefactor. I've been taking care of him 14 years. He has a well. Yes, it is both hooked up to house. We're on Molino water right now because both our pumps are out. But my biggest question on top of all of this is last time I was here, I was on an oxygen tank 3 years ago. He says he's going to go down 40, 50 feet. What prevents him from going down 80 feet once he gets the permit? If he clears out 12 feet of dirt going down on his 44 acres, that's over 500,000 cubic feet of dirt. Figure out how many dump truck loads that's going to be. Yeah. And what about the rule that says he can't have his trucks going out on a residential road? Do you agree to that? Isn't 95A actually a residential road with all them houses up and down that road? I've also got knowledge that on my road, Shag Road, 4 people that I know of got these cards that's got wells. I did not know about Kevin's house back over here. But he also has a swimming hole pond that's actually spring fed. They go down 40, 50 feet across the street from him.
Yes.
He's gonna lose his spring fed pond.
All right. Thank you very much.
May I speak in Joy's place that I'm in charge of? Do I get 3 minutes for him? He can't come up here and speak.
What is the board? The Board of County Commissioners, do they? I don't know if they allow that now.
I do not believe they do.
I don't, no, sir. I'm sorry.
Do what now?
No, sir. I'm sorry. That's not.
You don't get a voice, Joy.
Wesley Gunther? Could you face our clerk, Mr. Gunther?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. State your name and address.
Wesley Gunner, 2980 Keck Road, Molino, Florida.
Thank you for coming, sir. And what could you tell us, please?
So, several of the topics I was going to talk about have already been covered, but I was just going to touch base on Justin's character. I've known him for several years. We've had several dealings with each other. He's a good person. He does have plans to build a house there. He does want it to be a lake filled with water. He does have, I know somebody said something about power earlier. He does have power out there. So, I mean, we've talked about him building a house out there several times. So, but besides that, like I said, everything else has kind of already been touched base on.
Okay. Thank you, sir. Thank you for coming. Greg Rosoff?
Good morning, sir.
Good
Please raise
morning.
your hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name and address.
Greg Rossoff, 5601 Cedartown Road, Molino, Florida, 32577.
Yes, sir.
So yes, sir. I'm libertarian. What you want to do with your property, 100% on you.
Address the board, sir.
Oh, I'm sorry. I live right on the upper right-hand corner of the black line there. So long as there's no deleterious effect by any property owner on others around them, do what you do. It's yours. My concern is it's math. If in fact I understand you're going to potentially reduce the size from 44 acres in total. Originally, I did the calculations on 60 foot of depth. That's what I heard. 1,613 cubic yards per acre foot gives you 4.259 million cubic yards. At 40 foot depth, which is what I just heard, so we're looking at a 2.839 million cubic yards. Assuming 16 cubic yards per truck, we're looking somewhere between 266,000 and 177,000 truckloads. The attorney representing the owner had said, yes, look, there's a picture of a dump truck. We've heard that the Kites have dump trucks. Absolutely. We're talking about 250,000 truckloads of people coming on down. And I understand that the purview of this court does not necessarily take traffic into consideration. You just mentioned that. However, like Mr. Lowry had said, I have 2 young kids, it's a single dad, and my property is right on 95A. We're exposed to 250,000 trucks over some period of time that has not yet been defined. Can't really be defined because of the market conditions. It's not something I support. So.
All right, sir. Thank you very much. Tammy Kirkland.
Tammy Kirkland, 5115 Barronville Park School Road, Molino.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Go ahead.
Thank you. Just a couple of concerns. Some of my other concerns have already been addressed, so I'll be brief. Mr. Patterson has prior experience with another pit, so he kind of knows what he's going to be doing to the land and to the neighborhood and to the surrounding residents. His plans could change. He may intend to build a house, turn this into a lake, 10, 20 years, we don't know. The concern is property values in the area. I know I would not want to buy land next to or close to a pit, a dirt pit, whatever you want to call it. So property values would be one thing. The heavy equipment that he knows that it's gonna take to operate this pit, on top of the dump trucks, it's gonna be these heavy machine things, excavators, whatever you wanna call them. And the noise and everything that goes along with heavy equipment. Also, to run that heavy equipment, he's gonna have to haul in diesel fuel and store big tanks of diesel on the property to fuel these heavy equipment pieces. That would be another concern of that being out there. And the amount of truckloads per day, this gentleman put a figure to it, would be another concern. You know, how many in and out a day, compared to what's already there, going up and down 95A on a daily basis. Just other people running other businesses with their trucks. This would substantially just balloon into a lot of dump trucks going in and out. And then my concern is for the wetlands. And when you look at that wetland map, and another gentleman mentioned that we really need an expert, a wetland expert person tell us what's gonna happen to this if this is approved. So that's my concerns. Thank you.
Thank you, ma'am. Charles Sherwood.
This is my wife Debbie, so we can do two at once if you want.
All right,
One
sir.
right after the other.
Okay, that'll be
So
fine.
that it's more efficient.
All right, will you both raise your right hand? Do you both solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State name and address.
Charles Kevin Sherwood, 812 Josh Lane.
Deborah
Melina.
Sherwood, 812 Josh Lane.
Yes, ma'am. Well, we'll do one at a time, if you will.
Why don't you go ladies first?
All right.
Okay. I had a few concerns that most of the people before me have already addressed. But I do want to point out, number one, just because Ms. Kite's grandson or son or whoever has a dump truck on his property doesn't mean that he is running dump trucks in and out. We live straight across from where that entrance and exit is going to be for this borrow pit if you approve it. If you look at the map, Josh Lane is straight across from the entrance. Now, it doesn't show it on the map, but if you go on Josh Lane, in the pictures, I mean, you see a little bit of Josh Lane from that one picture. It's a dirt road. Then it goes downhill. We live down there. We have 3 spring-fed ponds. We just bought this property as our forever homes because he retired last year, and we can do that now. We wanted to get back into the Panhandle area because this is home to us after traveling with his job. So we looked for this. We found that 55 acres down there, plus or minus, with 3 ponds, a lot of woods. When it rains really hard, or even just when it sprinkles. There are 2 springs, as Miss Eula said, that goes down and goes across Josh Lane. They feed into our ponds. These are natural ponds. They are not man-made. On Josh Lane, I don't think anybody understands, really, because I don't think it's been pointed out, there are 4 wet residences. There's Miss Eula, there is her daughter, there is another residence, and then we are down at the very end, past the gate. So there are 4 residences right off of Josh Lane that are in, well, everybody else would be in the 1,000-foot line. We're right at, ours is down so far, we're right at 1,500 away from property, straight across. But I am so totally against this. If we had known that this was going on, and we're probably going to be fighting it for the next 10 years, because I'm sure you're going to come up with another plan, maybe change it a little bit, and it's going to keep coming back until until the property has been rezoned as the future plan states, to where it can't be there. So I want to live out on my forever home with our hunting land, with our fishing land, with my farmer, and our wildlife that comes in there. I'll let you handle that one.
Okay, so.
All right.
Basically, yeah, we bought this, we're down in the hollow, so it's in past Miss Eula. And those 2 springs she talked about is the ones that run down across. I have to fix the road, even though the county's supposed to come out and grade it every now and then, I have to fix it in between because of the way the runoff comes. So from Josh Lane, which is where they're gonna be coming in and out of, it's all downhill from there. We eat the fish out of the pond. I'm setting up stuff to we're gonna hunt off the land. We didn't have much time, we've only been here about 5 months. Got some watermelons, we're living off of that. Because I ain't got time to do the rest of it right now. We've been building, taking out trees and clearing stuff and getting things done. And some of the.
We're not doing it 12 hours a day.
Yeah.
No.
I'm gonna go sit down, or I'm gonna keep interrupting you.
That's the way Miss Eula knows I'm doing something, is when I cut something down. So, yes, the noise, we have a taxidermist that's about 980 feet to our south. The woods echo. So when him and his, I think it's his wife, we're talking on their porch, we're sitting on our porch, we hear 'em having a conversation. So the noise from those dump trucks and stuff like that is going to be complete, especially 6 to 6, right? You're going to hear that all the time. It's going to mess with the wildlife. The dust covering trees. We got, and that runoff right there at Josh Lane, there's a culvert that goes underneath 95A that goes down in my woods, coming from that property. So that's going to affect it as well. One of the bigger things is, though, we sat up way too late last night and watched the 2022. Same issue here. To get it educated. I don't like to come talk to people dumb. There's no difference. All these same issues are the same thing that was turned down 2 years ago. What's changed? So is this just something that every 6 months or a couple of years we just got to come back and rehash, even though it's already been decided and turned down? I mean, we're just trying to live out the rest of our life on this property in peace, get along with our neighbors. And I have heard things, like I said, I can't say that it's hearsay, but I have heard some discouraging comments against other people and threats. And I don't think that's good for a community. We're just moving in. We want to be part of the community. I want to be part of the wildlife, growing things and helping each other out and have peace. This ain't been very peaceful. And I'll tell you, and to talk about dump trucks up and down that road, I've been watching that real quick, and I'll stop. I've been watching that. Every one of those dump trucks going up and down 95A, even the school buses, you look at their tires on the right side, because to keep from hitting the car on the other side, they're running that white line with their right side. Now, I've been watching that the last week or two.
All right. Thank you, sir.
Thank
We
you very much.
appreciate your comments.
Can I comment or ask him a question, or just?
Well, actually, sir, you're represented. That's your attorney's prerogative.
Okay. You understand from what my client is saying, he wants to build a house there too, right?
That's what I'm hearing he wants to
And he
do.
wants to do a pond on that property, right?
Well, 44 acres, I don't care about size, but that deep, it's gonna
He wants to
affect.
build, he wants to make, regardless of what it is, he wants to make this his forever home. Isn't that what he said? Okay. And by the way, did you get the letter from Mr. Connors, the pamphlet that he ran around handing out?
I've seen one of them.
Have you talked to him?
Yes.
Okay. And he told you, he tried to convince you that he was gonna do something toxic on this property, didn't he?
No,
That's what the letter says, didn't it?
that ain't what we talked about.
But that's what the letter says, doesn't it?
I don't think it does. Is that a copy of it?
Okay, all right.
But the-
Gentlemen,
So the question is, he got you all stirred up, didn't he?
No. He got us informed,
Okay.
and we're smart enough to go out and look at stuff up ourselves,
Did you ever call my
including
client?
this meeting.
Did you ever call my client?
I don't have his phone number.
Did you ever, well,
Gate out there.
it's on the gate. Did you never bother to call him?
No.
Did you ever bother to come?
gentlemen, gentlemen, hey,
Because you don't live there.
gentlemen, gentlemen, this isn't
Point
productive.
being, it's,
This isn't productive. This is give and take, and it's just not productive to what the decision the board has to make. I appreciate your comments, sir, but I think you're.
I think I'm done.
Yes, sir. Wakita Henderson.
It's Jaquita.
I'm sorry.
It's Jaquita.
Oh, I'm sorry.
Son this morning.
Ms. Henderson, thank you for coming.
Hi.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. State your name and address.
I am Jaquita Parker Henderson. I live in Atlanta, so does my two sisters. This is air property that my grandmother, my great-grandmother, my great-great-grandmother owned before her, 5595A. We are in probate right now. My mom just passed last December. So we got the letter, and I just wanted to come and kind of see what this was all about. I'm convinced more than ever I don't want this. Our goal is to keep this property in our family. We own 3 parcels to pass down to our children. I don't know that any of my kids would want to live next to a borrow pit. I'm also concerned about the impact of the dust on the cemetery. My entire family, both sides, are in that cemetery. My mom, my dad, my maternal and paternal, every aunt, every cousin, everybody. And so I'm sitting there thinking, dust is going to be everywhere. And we do come in and pay people to help keep that cemetery clean because it matters to us. So as far as we're concerned, we're opposed. I get that, progress happens and people move on. But when this has been a part of something that's been in your family for over 100 years, it's kind of an emotional attachment. So I've not been convinced, listening to the testimony, that there are going to be enough safeguards to make sure that the property is safe, the environment's safe, the cemetery is safe, and that whatever barrier will be put up is going to stop all that dust from moving around. That's it.
If I can, just to clarify, you said that your address was 5595. Okay, that's my client's address. Aren't you, just so we're clear, you are the property to the bottom right, correct? Yeah, the bottom right of the resident.
Yes.
So, and that, nobody lives on that property, right?
Nope.
It's all timberland, right?
It's not all timberland. Nobody lives on it, no.
It's all a bunch of trees, isn't it?
It's a house there too.
Okay, all right, that's it.
Thank you, ma'am. We appreciate it, your testimony. Cody Banzik?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
My name is Cody Panzik. I live at 5675 Highway 95A North. I'm just north of what this picture shows here, but my property is within 1,000 feet of his. So, on top of many other things that have been said today, one of my biggest concerns is water contamination. When it sits there, it's going to get stagnant. Things decompose. It affects the water. On top of that, you have animal safety. Animals are going to fall into that pit. It's going to happen. And then as those decompose too, that's further contamination level. And on top of that, we want to keep our wildlife around there. And then we have autistic children. Autistic children are notorious for getting out. They don't care about gates. They don't care about no trespassing signs. They can fall in that pit as well. And on top of that, living in a rural agricultural community, one of the many treasures that we get to have is our animals. We have livestock. And one of the biggest livestock around there is chickens. Chickens are very sensitive to dust in the air. They have very sensitive respiratory systems. Dust in the air is going to hurt them. It's going to hurt all animals. And you cannot put enough trees around that to stop dust. You can't put trees above it to stop dust. It's going to happen. And it's going to affect animals. It's going to affect us. Dust into our lungs is not healthy. It can cause cancer. I've been through cancer before, and I'm not trying to do it again. That's not what I want in my area. It's not what I want for what I'm trying to build in my family. It's not welcome here. That's all I have. Thank you.
Robert McKillen? 6080 Cedartown Road. Okay, Mr. McKillen's not with us. Joshua Robertson. All right. Craig Exeter. 4601 Highway 196. Thank you, sir.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name and address.
My name is Craig C. Exner, and I live at 4601 Highway 196, Molina, Florida. And I would like to take a little bit of my time to thank the members of the board for coming and hearing a dispute that's happening in our community. I know that you don't get a lot of thank yous, but I want to say it. Thank you. My problem that I'm having has to do with the wetland. I am former president of the Barnum Park Historical Society, and Barnum Park goes to Old 29, 95A. And we have Jack's Branch, which starts in Molina, the headwaters, flows down, and eventually comes into Padita River. But it's a different item in the sense that it flows from the east to the west. Probably headwaters probably wouldn't be the best thing to say. It would probably be spring heads, as you've heard. Folks have springs there. A deep pit such as this probably would end the water flow in those springs. The water does not flow in a big river type of item, and because of that, it takes a long time to get from Molina over to Barnum Park. So I would urge you to think about that and different. Also, one thing that your staff did not put into you is there any historical impact on the area? We just mentioned the young lady that has land and she has relatives buried. Who knows? There may be folks that are actually buried on the land that he's going to dig up. People buried them in their backyards. That's where they put people. Didn't have money for funerals. Didn't have it. So I urge you, as you deliberate, to vote no on this. And again, thank you for your volunteer service.
Thank you, sir. Bonnie Exner? Yes, ma'am.
My better half.
Yeah. Yes, ma'am.
Do my swearing first.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name and address.
Good afternoon. My name is Bonnie Exner. I live at 4601 Highway 196, Molina, Florida. And mine is going to be short and sweet. I just have 3 questions to pose to this entire body. First question is a conditional borough pit. I don't see anything conditional about a big old hole like y'all are talking about. That's my first question. Second question, has any of the new conditions popped up since the other 2 denials? I don't see any, but I wasn't here, so I just leave it to y'all. Third question, if you as a board member, would you want a big old pit next to your residential home? In conclusion, I'm a retired teacher from Escambia County Public Schools, very proud of, and I taught at Wedgwood Middle School. And I have seen the devastation that they have carried through, and I urge you to deny this permit. I don't believe it's compatible with the adjacent properties in the immediate area as per your LDC Section 2-6.4. Thank you.
Thank you, ma'am. Jacqueline Rogers.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Thank
Okay,
you, ma'am.
I'm going to go really quickly since 3 minutes isn't long, but, so I'm going to speak to the criteria in the first part.
Ms. Rogers, will you state your name and
Oh, I'm
address?
sorry. My name is Jacqueline Rogers. Can I put this up? My name is Jacqueline Rogers, and I live at 1420 Ridgeway in Cantonment. I'm asking the board to deny this application because it does not meet the criterion, and I'm going to say which ones. A, general compatibility. It's not compatible with the surrounding adjacent properties. There's testimony, you've already heard that there's potable water wells there, even irrigation wells that'll irrigate agriculture and livestock cannot be contaminated. This property owner may alter the water table, and I'll talk a little bit about that too. When a borrow pit is there, they have to keep the water out to dig the dirt, and that will change the flooding and the stormwater composure. So it's not, with residential, that's why you have 1,000-foot criteria. With residential so close, it cause flooding adjacent neighbors, and it has in Wedgwood. That has been a problem. Criterion B is facilities. There are not adequate facilities, and I'm talking here roadways, which I'll put in with criterion C too, the on-site circulation. You saw a picture of the road. There are no shoulders on there. When you have constant truck traffic, and we're not talking about an occasional dump truck that is coming to service a resident, bring me a load of dirt, or we're going to have a subdivision built within a year. You're talking about potentially years of traffic. School buses going the opposite way with no shoulders, that's not good. You're talking about criterion D, nuisance, dust, noise, vibration. No matter how much you're going to try and suppress it, it's constant traffic, in and out, and that's how you make money. It's constant traffic. It's not occasional. The buffering, you cannot buffer adequately. Staff will say that they'll put adequate buffering in, but the neighborhood that's right adjacent to mine that's going in, it was a conservation neighborhood. They assured us there'd be buffering. They went right up to the property line. There's no buffering. Natural vegetation in this situation has been removed because the applicant has put a pig pen, hog pen on the property line. So all the base vegetation, the lower stuff that would stop dirt, is gone. Their house and a lake is proposed. I'm going to tell you why I'm here to support my community. I had a borrow pit go in my neighborhood. Rhodes Inc. owner Cody Rawson said the same thing. I'm putting a vacation home and a lake in. He never did that. He went all the way down into the sand in the aquifer. We had constant trucks coming in. I'm talking lined up 5 to 8 trucks coming in, going out. They make noise because they have to dump the truck. You hear the bang, you hear the bang. It hits a bump in the road, you're going to hear a bang too. Pits off of Highway 29 that he's talking about are Highway 29. That's a highway. 95A has residential highway. Criterion H, the environmental impact to the surrounding residents and the wetland area. Like he said, there goes to Jack's Branch, which goes to Perdido River, which goes to the bay. And the wells, the staff, I wanted to question, cross-examine, and I just want to say this one thing. Mr. Day, I live in Cottage Hill Waterworks. That's not on their maps. Cottage Hill Waterworks has maps. That is for the community. Molino has wells. That's not on their maps. Is that public? Is that protected?
Thank you, ma'am. We
Thank you.
appreciate it. Calvin Dixon, maybe?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. State your name and address.
Calvin Dixon, 9585 Cobblebrook Drive. My family owns the property right there next to the red line, going all the way to 95A, both sides of the street. And we have not had any contact from him asking for permission or any type of courtesy about what he's doing. Based on what he's talking about, my property, majority of his buffer is going to be my property. So I don't understand how that's justified as being able to be done. So I'm definitely against it. My family is against it. We have future plans that we're in discussions about, and that's definitely going to be a hindrance on us moving forward for its value or anything else of our property. That's it.
Quick question. Do you live on the property?
No.
You live in it?
Sir,
No.
I'm sorry. I'm sorry. Go ahead.
You don't live on the property, right?
No.
Are you related to the lady that came up a few moments ago? who
No.
lived in Atlanta?
No.
But she pointed that was the same property, sir.
She said something beneath that. All of my,
It's above Sean Road.
I don't know nothing about that. Right there,
So where you
The
at?
whole area, see where the red line is, it goes straight down,
Yeah,
that one there?
right.
Everything to the right of that,
Yeah.
on that side and across the street is my family property.
Right, that's what we were talking about earlier with that lady. Where do you live? I mean, you live in Pensacola or?
Yeah, I live in Pensacola.
Okay. And is it your family's land or yours?
It's my family property.
Okay, so how is he to know to contact you?
He didn't.
Okay, right. And did,
But if it's all documented. It's not it's me, it's my family, my mother, my other older family members.
And again-
And I spoke to none of them have been contacted.
and again,
I've actually spoke to Miss Ally Mae.
is that your relative?
Who?
Or what's her,
That's okay, that's okay. So, but it's just, right now it's trees on the property, right?
Uh-huh.
Okay. All right, and it's also trees, some trees on my client's property, correct?
Looks like, yeah, right there.
All right, that's all.
But that's gonna be
All
enough
right.
to be the buffer.
Okay. Thank you, sir. We appreciate your testimony. I'm sorry I didn't mean to interrupt you. I thought you were someone behind you.
That's fine.
Aaron Stillwater or yes.
I'll go last if you don't mind, because I ain't got nowhere to be but here.
Okay. All right. You will join with
I already did that earlier, the first two. You saw that?
well, you can join with Ms. Hostler, and you two will have the
We'll wrap it up.
swan song. All right. Brent Gunther, Mr. 9890. Oh, geez. I'm not sure I can make this one out. Brett, maybe Gunner or Gunter? Brent? Is there a Brent? Okay. If you signed up at the end and didn't get a chance to speak, let me know. I may have just read you and couldn't read you. I couldn't read your name correctly, which is on me. Mr. Irvin Scott. Is Mr. Scott with us today? Mr. Scott. Okay. James Colvin. Mr. Colvin with us today? Okay. Cynthia Robbins? Is Miss Robinson with us? 5367 Highway 95? James H. Vaughn. Mr. Vaughn, okay. Honestly, 5184. Is that you, sir? Okay, all right. Good, I'm glad I finally got one. Yeah.
Please
Could you
raise-
raise your right hand and face the clerk, please?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name and address.
Kevin L. Keener, 5184 Shad Road. And if y'all have a pointer, or I'll come up here, because I don't want nobody to get lost. I'm gonna tell y'all what y'all need.
We need you at the mic, sir.
Well, I want to say, okay. See all that blue watershed coming down through there? Okay. Right below you, that first part, that's me. Okay. All that blue watershed is low. All right? And everything else is high. Sound goes through that watershed like an amplifier. And if you want to hear backup or all, 'cause I've done construction, worked on heavy equipment. I had my own welding business. I maintained equipment, all 2,000 cubic yards a day for 7 to 9 months a year for 12 years out of paper mill to the south. And look here, and the tailgate slamming you talking about, they do that when they dump, so it slams and knocks the dirt out of the truck. I'm not against anybody, man, doing what he wants to do on his property, as long as it's coherent with everybody else. But look here, if you sit on my back porch and listen to those backup horns, it's not beep, 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 it's beep, beep. I've been talking about me, we can't hear each other. And when those tailgates slam, you'll jump. I mean, you see that blue, how it comes right in the middle of your property, and still it comes together? Well, on that corner, that watershed goes, that's the head of Jackson Bench is straight across. Comes out. Okay? And I'm going to tell you about your depth. Because the man that built these wells, I also maintained his equipment. And it's changed for my well. I'm going to tell you what he's sitting on. Because 30 years ago, the water company tried to buy my property because of what's under that ground. And your depth is what's got you messed up. All these ponds, that's a 6 to 26 water table. You hit water at 6 foot to 26 foot. Okay, at 55 foot, you're gonna hit that aquifer. It stayed. I was right there. This ain't hearsay. I was right there with the drill bit. You know your water is chattering. You collected what's coming out, the blue crystals. Water company. I'm sitting on some of the best water in the county, and it does. Look here. If you get to that next water table, you've gone too far. 6 to 26. That's what all the water. That's everybody's ponds. That's the springs. You below that, you're gonna knock the bottom out, and this is my concern. And that watershed, every form of wildlife known to exist in Northwest Florida is in that watershed. I've got panthers, snakes, there's moccasins in there. They'll bite you in the face from the ground, mouths that big. Rattlesnakes like that. And he's driving them, all that bam, bam, bam. You're driving all of it out of that watershed over to the other side. Most of it's coming up in my yard to that watershed right there. I'm gonna have to relocate something. I'm tired of killing the snakes here the last couple of months. But that little bit of work you did earlier, that bang, 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 it drove them. It's hurting them, too.
Thank you.
Okay.
Thank you, sir. Laureth Bellamy? Is Miss Bellamy with us? Okay. Sarah Walton.
She's with me.
I'm with him, so I'm not going to speak.
Oh, all right. Thank you, ma'am. And so we turn to our last two, Dawn Hostler. Would you like to be first? All right. Well, then, Mr. Stillwater, we look forward to hearing you.
Hey, you got my name right both halves, except for I thought it was AA wrong.
Yeah, well, I guess.
Aaron Stillwater, 3325 South Highway 97, Cantonment, Florida.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
I did. I don't live by y'all. I live over on 97 behind Divine Farm. So I've had firsthand knowledge of how Justin runs a pit. Now, he started originally with a partner, so that was a little bit different, and I think they even had a few hurdles they had to jump along the way. So hurdle jumping, he's gotten pretty good at. Now, we get better as we jump more hurdles in life. That's who makes us, right? So what I have found, you go by the Wedgewood pit, it's clean. There's dust control. There's sprinklers on the ground, so whoever's worried about plowing a field, I can promise you there's less dust coming from the pit than there is any field I've ever cut, any bush hogging I've ever done, or any disking I've ever done. So, any of y'all ever done that and had to breathe it, you already know. Divine Farms, everybody's talking about property value. Ain't Iron Rock being built right on 97? That's some fine houses right there. And all the way up 97, right? There's no production, not stopping. It hasn't slowed anything down. Now, I hate that it's going to upset a few people, but I also thought, aren't there other entities that make sure this is just the first step? You can dig a hole, put a shovel in the ground. Next step is somebody else comes and tells them, hey, those trees ain't ready. You got more sprinklers need to go down, right? Is that correct? That's a question. So if you're gonna always upset the people that are around you. And I thought I was gonna be upset being next to a dirt pit. For one, they're usually not emptying dump trucks, y'all. They're filling them and hauling them out. Now, you might hear a excavator or a loader bucket tap a side here and there, and you're right, it does, well, wherever he went, it does travel down the sound a little, but not always, sometimes. When the wind blows right, you'll hear anything anywhere. So Justin's shown to be responsible. He's shown to work with the communities as best he can. You know, you just gotta give him a chance. So from a character witness, I've known him for almost 10 years now. Well, maybe 7. However old Divine was. I tell you, I'll give him a chance. But here's the other thing. He already told you. He's already started with the small permit first, which I think that's how Divine was, like 20. And then about wore him out, and they couldn't provide enough dirt at that point in time because they had to ask for more and got delayed there. So he's asking for more now, plan on doing less. But anybody that thinks you can get 44 acres dug in, I mean, it takes a long time to fill dump trucks all day long. I mean, it doesn't just blow out of the ground. That'd be nice, but everybody'd be doing it then. So I'd say go for it.
Okay, thank you, sir. And Ms. Hollister.
Well, good afternoon. I thought it was still morning.
Yeah.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you. State your name and address.
Name is Dawn Hollister. My physical address is 10,001 North Palafox. I debated heavily about whether or not to speak, which is one of the reasons I asked the board to delay my speaking. To be perfectly transparent, I do work for Attorney Talbot and know Mr. Patterson that way, but I am also a new resident of Pensacola. I sold a $450,000 home on a golf course in a very heavily developed area, very far north of here. And this, for me, was supposed to be my quiet step back, my step of peace. I wanted a quieter environment. I'm tired of the buildup. I'm tired of the trucks. I'm tired of the overdeveloped. I've been through the issues with the wells. I've been through the issues with the noise. I've raised 13 children. They're now grown, and I want peace and quiet. And a thought keeps coming to my mind. I hear all your concerns. And I've met Mr. Patterson. And most of you don't know him personally, and what I've met is a person who is a lot humbler than he may come across, probably because he's really nervous and he's trying really hard to do the right thing by everybody. He genuinely cares about this community's input and how it impacts his neighbors. He's taken every possible precaution and has taken steps and jumping through every hoop thrown his way to make sure this is done the right way for him. And one thought keeps coming to my mind, and I asked him, and actually, if it's okay, can I ask Mr. Patterson a question? Because I have not asked him this I haven't asked him directly. May I ask Mr. Patterson a question?
No, ma'am.
Okay.
Okay.
My concern is in an area that I've just moved to avoid the noise and the chaos and the overdevelopment. That's a huge chunk of land. And if he didn't pick it up and looking to develop his permanent home on it eventually, yes, he's trying to make $1 while he's putting up his home. That's the American way. He's doing it in a way that pays for his long-term dream. He's trying to be a responsible citizen. If he doesn't build there, who's going to build there? 400 new homes with permanent traffic for the next 100 years, extra capacity issues with your local schools and everything else. That's an extra tax burden on the community. Where's that tax burden going to fall? That's going to fall on me as a new citizen. That's going to fall on every one of you. That's going to fall on your children and your grandchildren who own that property after you. So long-term wise, I am absolutely, as a citizen and not as someone who works for Mr. Talbot, but as somebody who's new to the community, I don't want a huge another super development coming in with 400 new homes. I would rather see something there that's maybe seem inconvenient at the time, but over the long term, where my children are gonna come visit and my grandchildren are gonna come visit. Thank you.
Thank you, ma'am. Board, that is the end of our speakers list. Is there anyone who hasn't spoken that would like to speak? Well, could you fill out a blue slip, Mr. You can fill that out afterwards.
We'll get it. It's coming up. We'll get it for you. We'll get it for you. Okay, that's fine.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name and address.
Michael Mack, 2201 Nolan Faulkner Court, Cantonment, Florida, 32533. My dad and I purchased the property just to the west of his property on the other side of the branch. Yeah, 40 acres right there. I don't know Mr. Patterson's character. I think it's irrelevant to this topic, to be honest. I mean, there's a reason that there's a contingent use on putting in borrow pits on agricultural property. I understand. This isn't one house that's on a farm somewhere that happens to be within 1,000 feet of this borrow pit. This is, I can't count them all, what, 15, 20 homes within 1,000 feet of this borrow pit. I talked last time, I'm gonna make the same statement. Have any of you ever seen a borrow pit? Have you ever been to one? Do you wanna live by one? None of these people do. Nobody around here wants to live by one. Nobody who lives in that community wants to live by one. I mean, that should be enough to make a decision. There doesn't need to be a borrow pit in the community. Doesn't need to be there, period. It has nothing to do with character. I don't know the guy. Don't care to know the guy. It doesn't matter to me. That's not the point. The point is, there's gonna be a 40-foot deep hole, 44 acres big in this pit. Could he build a house later? Maybe. We don't know that. There's no guarantee that he's going to fill it up with water and make a lake and put a house on it. No guarantee whatsoever. There's no way you can guarantee that. What if he dies halfway through this and somebody else buys it out? You never know what's going to happen with it. You have no idea. So that's my piece. I'm against it.
Thank you, sir.
Yes.
Could you fill out a blue slip?
Yes.
Mr. Talbot has a question.
Did you buy your property from Eric Lee?
Yes.
Okay, the property's owned by whom? Your property, 40 acres.
Mac Properties of Northwest Florida.
Y'all are a property, a housing development?
No, we build custom homes,
Okay.
but
Do you buy, and then what are you gonna do with this property?
no idea yet. Depends on if there's a borrow pit behind it.
Did Eric Lee, well, and did Eric Leeton tell you disclose to you that this had application for a borough
To
pit?
me personally, no, I can't speak on behalf of my dad.
Okay, and actually, I think one of his agents was here, you didn't know that?
No.
Okay, and, but, that's all.
Thank you, sir. Please fill out the blue slip. Thank you. Board, now we have heard from everyone who wants to speak, and we have reached the point towards the end. We do have, you have two witnesses you want to call, if I understand.
That's correct.
Well, I'll tell you what, why don't you go ahead and call your witnesses now?
Mr. Merrill?
Is Mr. Day in the house also? Mr. Day, could you stand by? I think the board may have a question or two for you.
William Merrill, 1164 Finch Drive. I've already been sworn in.
Yes.
Mr. Merrill, do you have a group of exhibits there? I want to show you what is exhibit 4.
We're entitled to copies of exhibits.
Well,
Board,
we haven't seen any exhibits either, so.
Mr. Chairman, these were emailed to staff yesterday. It didn't make it in the packet, and so you would need to accept it.
Yes, sir. All right, well, I'll tell you what, why don't we get them and let us look at it, and then we can.
We were told to submit it by 3 yesterday, which is what we did.
Well, I'm sure that you did.
Oh, I see.
let us look at what we're talking about, and then we'll make a decision on accepting the amendment. And then at that point, we'll turn it over to you.
Okay, well, should I ask the witness questions now and then introduce the exhibit later?
I think, let us look at the exhibits. I think that might be quicker. It just,
I'm waiting for y'all to look at the exhibits.
do you have a copy?
Yes, they were sent, and I looked through them yesterday. I
Okay.
would tell you there's going to be portions of this that I'm going to tell you are not relevant.
Yes,
And
well-
our objection
well,
would be
that's
to that.
One of the reasons we need to look at them.
Yep.
If you've got something to pass around.
We can pull it up for you.
All right, well, okay, why don't we do that? Or
they
is
wanna-
that acceptable? You know, we've had this situation arise before about exhibits.
Do we know how many exhibits we're talking about? How many?
Well, we are in suspense also, sir, and we will know shortly. If you'll just watch the monitor, you're gonna see what we're gonna see.
Well-
I promise.
Okay.
Okay?
Okay, well, I can do that. I may not need to present all of them. I just want to present the ones that this witness will be talking about. First, let's start with Exhibit 4.
All right. Tell you what, before you get started, let us look through these. That's normally what we do. And then the board will decide whether or not to accept them in. If they're accepted in, then of course we'll turn them over to you to, have Mr.
Should we take a
Merrill.
vote or something while y'all do that, or I just don't know procedurally what you would like us to do?
No, well, I'll tell you what, just let us look through the ones that you intend to offer. What I'm trying to do is get them on the record.
Well, that's fine.
Right.
I'm just doing it however you want me to do, is what I'll do.
All right.
And I just want copies of them so we can at least have an opportunity to object to certain items. because
Well,
we-
yes, sir, you have in front of you, I hope,
No, sir, I don't have anything in my, the due process.
there's nothing up there?
No, sir, there's one copy up here, but, I think we're entitled to some time at least to find out what he's planning to do and look through them and, assert any objections.
Well,
Because this exhibit, at the very end of a hearing is problematic.
I can only tell you this, that the board hasn't seen them and has to make a decision on whether or not that they are accepted into evidence. If they're not accepted into evidence, then that's the end of the matter. If they are, at that point, we can look at whatever objections each side or comments each side has got. But right now, the board needs to look at them.
Mr. Chairman, just so you know, it's broken out and marked by each exhibit if he's going to use them individually as the exhibits. It is 67 total pages.
Oh, okay. Well, that's,
Let me suggest, Mr. Godwin, that some of those exhibits aren't necessary for where we are in this case at this time.
all right.
I think that the exhibit number 1, which is 1 page, exhibit number 2, which is 1 page, exhibit number 3, which is 1 page, and exhibit number 4, which is 1 page, pretty much is what I would like and exhibit 5, which is a couple of pages, or 1 page rather, is what we need to do at this point.
All right, then let's start with Exhibit 1. Mr. Talbot, do you see Exhibit 1?
Yes, I have a copy.
All right, sir. Why don't you tell us what that is, and we will, board, I think probably we're going to have to just take each one individually, and we'll hear what the explanation is, and then I guess we'll, at that point, vote to accept or reject them into evidence. All right, sir. Number one.
Mr. Merrill, do you recognize that?
I'm sorry, he coughed. I didn't hear the rest of that.
Do you recognize that exhibit?
I've seen that exhibit, yes, sir.
What is it?
It's an aerial photograph of the Molina area, including the Patterson pit.
Oriented, sorry, north is to your right, if that helps.
Okay, could we admit that exhibit?
And Mr. Merrill, can you tell us about this exhibit? Where was it, when was it taken, who took it? What does it purport to represent, and things like that?
Mr. Merrill, if you didn't take the picture or prepare the document, I'll move on and we'll have Mr. Connors testify.
I did not prepare the exhibit, so I can't.
Let's go to exhibit 4, so that maybe we might move this along. Did you prepare exhibit 4?
I did.
All right, would you tell the board what exhibit 4 depicts?
Yes, this is taken from Google Earth aerial photograph. Overlaid on it is an outline of the pit that came from the engineer's plan that's in your package. And there's several other arrows and descriptors to different residences and wells in the immediate area that we knew about.
You prepared it?
I did.
I move its submission into evidence for this proceeding.
We'd object, calls for hearsay. This is, and the only other way he can find out, he has not laid a proper predicate as to his knowledge of residences, wells, etc. And the only way he can find that out is to take somebody else's word for it. That's hearsay.
Mr. Godwin, this is a quasi-judicial proceeding. The rules are construed liberally. Mr. Talbot's objection based upon hearsay is, quite frankly, under the circumstances of this kind of proceeding, quite irregular. We've done this previously. The staff has produced photos. The staff is given reports based on what they've heard from other people. This witness can testify about what he put on this and where the information came from.
He hasn't done that yet. Let him testify. He's gonna testify about it. Let him find out where he got that information from.
Mr. Merrill, what sources did you consult to prepare the legend that is on the map?
Most of it is from the Escambia County property appraisers. I also visited the site, and that's how I located Mr. Connors' well and his house.
Wetlands, for example, how did you come up with that particular? Was that from what source?
That came from the plans that this application submitted. Wetland Sciences located those wetlands, and I overlaid them on the aerial.
Okay. All right. Board, any comments on this exhibit? It appears to me that it's an acceptable representation of what we're dealing with. Do I hear a motion on it?
I'll make a motion that we accept this into evidence for further decision.
All right.
I'll second.
We have a second. All those in favor of accepting exhibit number 4?
May I have a second? May I have a second?
I second.
Marty, thank you.
All right. All those in favor?
And sir, if I can, for the record, is he limited to the 3 minutes like everybody else was?
No, he is appearing as an expert.
So, okay, so in that situation, same thing. Mr. Connors would be limited to 3 minutes?
Mr. Connors is my client.
Correct. He's
Well,
just like
he's
everybody
the-
else. Everybody else is limited to 3 minutes. So Mr. Connors, we need to, if we're gonna move this along, Mr. Connors should be limited to 3 minutes as well.
We addressed this issue at the beginning.
Yes.
No, we did, I don't think we didn't have a decision.
No, Mr. Talbot, when Mr. Connors appears, we will, we may discuss this further, but at this point, we're dealing with Mr. Merrill. Mr. Merrill's an expert, and he is, I think the board is entitled to hear his expert opinion, and which is not going to be 3 minutes, I would think.
Sorry, you didn't do the majority.
I'm sorry, I can't hear you.
Oh, yes, so you got your motions, but, and then you voted, but you didn't state the outcome of that vote. You wanted to go back.
Yes.
Mr. Palliser talked.
Yes, the motion, we voted and it passed unanimously. We accepted the exhibit into evidence. Thank you.
Mr. Merrill, how many residences are within 1,000 feet of the site for the proposed pit?
I calculated 27. It could be a couple less because there's some transient trailers there. I wasn't sure, but it's 25 to 27.
Within 1,000 feet of the pit?
That's correct.
Have you any information with respect to how close the proposed pit will be to the well on Mr. Connors' property?
Yes, his well is fairly close to the property line. You got a 50-foot buffer proposed. It's about 70 feet
His well is 70 feet from the pit?
from the pit.
How about the well on Ms. Dorch's property? How close to the actual pit will that be, or is it?
It's just under 200 feet.
Are you aware of any other wells within 500 feet of the proposed pit?
Not specifically, but I heard today that there's probably others in the area that we don't know about.
The witnesses who testified previously have said they've had wells.
That's
or
correct.
do have wells, I'll say. Do you understand, or do you have an opinion with respect to whether this particular pit will be susceptible of transition to a lake or a pond?
Well, I guess in this application, which I don't remember getting one the last time, there was a reclamation pit plan that showed a lake on it. So we've got two plans. We've got engineers' plans, and then following those is a reclamation plan. And if you look at those two, he shows digging down about 50 feet for the borrow pit. But when you look at where he's digging, and then in the reclamation plan, there's no water shown on areas where he's digging. So the two plans are inconsistent. So I don't know how that reclamation plan could be implemented unless the engineering plan is going to be altered down the line. Or the third possibility, and probably the one that doesn't make the most sense to me, is that he would bring a bunch of fill back in to then shape it. But in my opinion, the two plans, there's not enough detail on the reclamation plan to really form a real opinion, but I see the two in conflict and pretty significant conflict.
Mr. Merrill, you appeared and testified in connection with the application in 2021, did you not?
That's correct.
And so you are familiar with that application?
I am.
You appeared and testified in connection with the application in 2022, did you not?
I did.
And you're familiar with that application?
I am.
How does the current application differ from the prior two applications?
Well, the current application is basically identical to the 2022 application, other than there was an addition of a reclamation plan that I don't remember from the 2022 plan. I didn't have it in my files. The 2021 and 2022 plans are very, very similar, but I remember they added some buffering on particularly the south side, but I think on a couple other sides.
The buffering that's on the current plan, is it the same buffering that was on the 2022 plan?
That's correct.
Were you here when the board voted 6-0 in favor of denying that application?
I was.
The buffer is the same now as it was then.
That's correct.
Is the location of the pit the same in the current application as in the prior two?
Yes.
What is your understanding of how long a borrow pit operates or can operate?
Well, I mean, it can operate indefinitely. I mean, it's gonna come down to, how fast they remove the material, but, you know, and we don't know what that takedown rate is. So I worked through a bunch of examples and tried to figure out, I mean, they're in excess of 100,000, probably more truck trips coming out of there.
100,000 truck trips?
100,000 truck trips. So, I mean, for example, if a truck left every 30 minutes, 6 days a week, 8 hours a day, we're at 20-something years. And that doesn't include holidays, rains, recessions. Granted, there'll be a little faster rate at sometimes, but I'm looking at average rate.
20 years?
20.
And when does the pond become a lake according to this plan?
It would be after the pit, after they were done excavating the pit, and then they would reclaim the land.
So the pond or the reclamation would be conceivably 20, in fact, likely 20 years hence.
I agree.
What is the effect, if you know, of this 60-foot, 40-plus acre hole in the ground on the adjoining wetlands?
Well,
An objection. He's not been established as an expert with regard to wetland science. He's a civil engineering.
I stand by the witness's competence to testify as an expert, especially on a matter having to do with a 60-foot, 40-plus acre hole in the ground next to a wetland.
That is an absolute falsity, and I want to make sure it's clear on the record. He is not digging a 60-foot hole, 40 acres. It's a sloped piece of property. So when you had testimony talk about how many cubic feet a 60-foot down is over 40 acres, that's not what we're talking about. It's going to be straight dig.
Mr. Talbot, first of all, let me observe that I'm sure you misspoke. I'm sure that you didn't intend to say falsity. You may say that it was incorrect, but I don't think it was what I would understand a falsity to be. Now, as to your objection, I also would like to know, we have recognized Mr. Merrill as a civil engineer. I have no issue with you requesting that he tell us about how he is a wetlands expert also. Now, if that's your objection and your comment, then it's well-founded in my opinion. Is that your?
Yes, sir, that was my objection to his qualifications on the wetlands issue.
Okay. Mr. Merrill, can you tell us how you're a wetlands? We fully respect your civil engineering abilities, and you are, like I said before, well-known to the county in that area. Now, tell us about your wetland experience to be able to offer that opinion.
I permitted a lot of wetland field projects, and have dealt extensively with wetlands, but I'm not stating that I'm a wetlands expert.
So you're not stating you're a wetlands expert? Mr. Bates, I don't think your question is germane. You don't have, Mr. Merrill stated he doesn't know, he's not a wetlands expert.
Mr. Merrill, can you tell from the application, pardon me, thank you. I won't pursue that further.
Yeah.
Mr. Merrill, can you tell me from the application what the nature of the buffer is
I cannot. I know that there's some engineering plans that came with it, and the wording on it varied. In some places, it said vegetated natural buffer, and other areas it said vegetated landscape buffer, and there's just not enough detail for me to say what's going there.
Is natural vegetation an effective buffer?
It can be over a long time, and it depends. It depends on how thick, how much, how wide.
Do you know that the Land Development Code ultimately will prohibit borrow pits at or near existing residential uses?
I object. It's argumentative. It's a compound question.
Do you know, I'll reword it. Do you know what the Land Development Code intends to, or is going to provide, or does provide for effective, I think, 2030 about wells and borrow pits?
I do know that the Escambia County Comp Plan, there's a section 12 in the comp plan, and and I understand the comp plan is what drives the land development code, but comp plan talks about resource extracting and basically mining. And one section says additional resource extraction in the form of borrow pits will be prohibited abutting state and federal parks within floodlands or near existing residential uses, and it goes on to discuss residential zoning districts and subdivisions. So I presume because the 2030 comp plan is prohibiting borrow pits adjacent to residential or in near residential homes, that's where they would ultimately go.
All right, as far as the Land Development Code and the comp plan, do you have a view or an opinion about why they would prohibit this in the future for all residential areas? Not a conditional use exception, but a prohibition.
Well, I'm assuming it's to prevent
I'm
the kind
objecting.
of quality of life issues
I'm
everybody here is
objection,
facing.
sir, please.
What, and your objection
My
is?
objection is it calls for speculation, and it calls for the reasoning. He's asked to ask them, what is the reason for the statute? And that is a interpretation, that's an opinion, and it's not an opinion, he's qualified.
It's a sustainable objection. Mr. Bates, can we?
Yes, sir.
Move on?
Thank you. What will feed this, pardon me, I'm gonna back off of that for a minute, just a second. What is, you said earlier that converting this pit or this hole in the ground to a pond or a lake will require some changes. Would you tell the board exactly what those changes are and why they will be necessary?
Yes, Drew, can I get the exhibits of the actually engineered plan, one with the contours on it?
I can pull that up, and just so the board knows, that was part of the submitted package from the applicant. It's in the meeting package.
Do we need to take it into evidence?
No,
Do we
sir,
need to
it's,
take it into
you already
evidence?
accepted it
Oh, okay.
at the beginning of the
It's
meeting.
what we've already got.
Yes,
Okay.
sir.
Yeah,
Yes, sir.
okay. I thought
It's all the way
it
down
might
near
have
the
been.
bottom. There you go.
That's it.
Oh, yeah, zoom out.
Yeah. All right, if you look on the southwest side, it's that finger sticking out there. The contours on that show the pond being excavated down to elevation 100. And we don't have groundwater data from the geotechnical, but it's pretty clear that to me, the groundwater is significantly higher. When in planning, which we're doing right now, usually you kind of look at the wetland line, and that gives you an idea of about where the water will be for planning purposes, and you'll follow up with the details. But that kind of finger on the bottom left, for example, would be, I don't know, 30 to 40 feet below the water line is what I'm estimating right here. Now, if you can show the reclaim plan, which is the last one. Now, keep on coming down. Now, if you see that same finger down there on the bottom left, it's all high and dry land now. How do you excavate down 30 plus feet below the groundwater with a borrow pit, and then when you rebuild it, you build a lake that's smaller than the footprint of what you excavated out? And that's why I'm saying there's only a couple of choices. The reclaim plan is not what they plan to do. The engineered plan is not what they plan to do. Or are they gonna fill in somewhere else to make that? And that's the basis of me saying why the two drawings are not compatible.
Who drew that engineering plan that we're looking at on the table, or on the screen?
I do not know.
Why don't you know?
It's not labeled, it's not anywhere on the plan is indicated who drew it. Usually there's some spots for the technician to say they drew it, it's just all blank.
Is that common? That it would be all blank?
No,
It's not common.
no, generally who draws it, you wanna have some reference, particularly if it's an engineering architectural firm, they wanna know where that drawing came from, so I just don't know.
What, when you said they would have to bring in dirt, what exactly would they have to bring in dirt to do?
Well, the areas that this reclamation plan shows as dry land, particularly along that finger, the engineer's plan would have that 35 feet below the groundwater. So in order to get rid of the water and make that dry land, you'd have to fill it back up.
So the people that were hauling the dirt out would have to be hauling it back in. Is that correct?
Yes, if not from off-site, somewhere on site, could they go deeper than 40, 50 feet? I don't know. I just don't have that detail, but it doesn't make sense to me that you would spend the effort to excavate all those areas and then fill them back.
I heard some testimony from people having to do with noise. Is vegetation effective as a noise buffer?
I mean, it can slow it down. I do not believe, it's not my experience being on a lot of construction jobs that 50 feet of trees is gonna eliminate it.
With respect to the dust, is there some notion in your mind that vegetation would prohibit dust contamination on adjoining properties?
Again, it could slow some of it down. My personal experience is that it won't all of it unless they're very, very tight with their dust control.
What is their proposal for dust control?
I didn't see any specifics in the application, much of anything, other than what I've heard today was sprinklers and wetting it down and other measures.
That's all the questions I have.
Mr. Talbot?
Yes, sir, very briefly. Mr. Merrill, the fact that something is permitted does not mean they have to dig it, right?
I would agree.
Okay. And in fact, wouldn't you agree, as a civil engineer with 20 years' experience, you would ask for something probably to get permitted for more than you actually want? Because you don't have to go back and re-go through the process, right?
I can't think of a time I've done that. But I'm not saying it's an invalid strategy.
All right. So when you reference the finger, that was sticking out in the southwest, if my client didn't dig that area out, it doesn't need to be refilled in, right?
Certainly.
Okay. And sir, when you talk about the edges, it's not gonna go straight down all the way to the ground. You're gonna have to go out at an angle, correct?
That's correct.
Okay. And the angle has to be 2-to-1 ratio, correct? At least.
The original application, which was in 2021, showed 2-to-1 side
But
slopes.
the regulations, according to the rules, it's 2-to-1 at least. If you're steeper, you gotta get special approval, right?
I agree.
Okay, so if you go 2-to-1, that means 2 foot over for 1 foot down.
That's correct.
Okay, so if you're going 2 foot over for 1 foot down, to get over, it's not gonna be a big ditch, it's gonna be more at an angle, right? More at a pyramid shape.
Yes, I agree.
Yes,
The
okay.
slopes have to be, the side slopes have to be, have some slope to them.
Right, so when you look at the size, again, it's gonna be more of a pyramid or even less of a top of a pyramid. It's gonna be more of a bowl shape, fair to say? Because you gotta get vehicles down there.
I don't know if a bowl is the right word for it, but I guess if Drew could put up the actual plan they're proposing. Drew, could you put up the previous page? And if you see the dark lines, I mean, those are the side slopes.
Okay, but the side, all of those type of things though are handled in the next stage, correct?
I hope so.
Right.
Yes.
As a fact, you've been here to hear the testimony, you heard, haven't you been in the Development Review Committee?
I have.
Okay, that's where you made those decisions about the specific buffering, the, how far down, that's when you get more technical, right?
I would agree.
Okay, so when you say you imagine, it's actually where it is, you know it is, don't you? You know it's in that next committee is where they get specifics on technicals, right?
I would say that, but those are pretty specific drawings, the engineering drawings. So I don't know, and I guess when I see engineering drawing of that detail, it tells me that's what they're probably trying to build. Now,
Well-
if that's not what they are, then yes. If there's gonna be big changes to that drawing, but I can only give testimony on what I see.
Now, sir, the reclamation plan has not been adopted and signed by the board, correct?
I agree.
So that's just a proposed reclamation plan, correct?
It's marked preliminary.
Now, you indicated that buffers, you said that trees, stuff like that can be buffers for dust, correct?
They can buffer dust, yeah.
And you also try to buffer areas by using dust suppression like water spray and stuff of that nature, right?
Right.
Okay. And so there's mechanisms so that you can control any dust that comes off this property. Isn't that fair to say?
My experience of those mechanisms, if implemented very, very tightly, with tight control, can be effective.
And in this case, my client is submitting himself to the county for regulation, isn't he?
Yes,
Okay, so that they can exercise that tight control, as you say, correct?
yes.
Okay. Sir, when you reference your exhibit number 1, how many, I'm sorry, yeah, it was exhibit number 4. When you said how many houses did you say were within 1,000 feet?
I remember between 25 to 27.
25 to 27 houses. Did you count those?
I went on the property appraisers. and did.
Because I went on the property appraiser too, and it was 1,000 feet from Mr. Connor's home to the road. So if that's 1,000 feet from his corner, and he's at the far corner of the bottom right of the property, correct? You've identified on this, in other words, if you look at exhibit 4, you've identified residences that were much further away than 1,000 feet, didn't you?
I would have to look,
For example, there's one that says residences.
but that's not from Mr. Connor's home, it's from every corner of the pit. It's
Well,
1,000 feet out.
Here's Connor's property at the bottom right of the 4 corners of the pit.
Right.
It's 1,000 feet from there to the street.
About so, yeah.
Right, I personally did
Yeah.
that on the property appraisal, but you listed residences on the other side of Highway 95A. So you included residences that were not within 1,000 feet, that were beyond 1,000 feet.
But that's from his corner, is you've got to do 1,000 foot off of every,
Right. well, we can
every
do that,
part of his property.
But we will, But the bottom right, on the bottom right, where the Connors property is, you included properties, looks like at least three puppies on from the bottom right that are more than 1,000 feet. 4, it might be 4.
You may be correct, you may be correct.
Right, and you also identified, looks like right above Sean Drive, you've identified 2 people there too, right? Residences. Somebody living at those?
Right.
Does somebody live there?
I don't know, I pulled that from the property appraisers.
But so you don't know, when you identify residences, you don't know if these are abandoned homes like the people testified earlier?
I just go with what the property appraiser said what the use is.
Right.
It says single family or vacant.
And right, if you look at the top right corner of your property, or the top right corner of your the property where it's going to be, you included residences on this one that are beyond 1,000 feet too, didn't you?
Yeah, the drawing wasn't meant to show resident just 1,000 feet. The drawing is meant to show everything, the whole area.
But
It
you,
wasn't.
right, but you included residences that were well outside of 1,000 feet, did you not?
I wouldn't say well outside, but those up there, I would have to go back and look and run a scale on them. I'm not sure, but I was thinking most of these are in 1,000 and a few of them are out. is
Did you
what I was
actually
remembering.
measure these, sir?
On the air, yeah, I did, on Google Earth.
So your testimony under oath, that those houses that are up at Cedar Town Road, you identified 2, those 2 are within 1,000 feet?
Yes, because if you look at the 500-foot radius, you can double that from the corner of the pit, the other corner.
Can I?
No.
Sure.
Write it down. Now, sir, the issue of the wells, and you said you thought the wells addressed, you would agree this is not, he's not putting deleterious items, buried items, right?
I've not seen any mention of that.
And he's not gonna fill it with land waste, construction waste, or anything of that nature, correct?
There's certainly no documents for that.
And wouldn't you agree that the Wetlands Protection Statute references those 3 items? If you apply in the wetlands area, if it is deleterious or other waste like that.
I'm not sure what rule you're looking at.
All
I'm
right.
not sure.
You're aware, though, that the county, you heard that the county has already interpreted this to be a public potable well in regulation, correct?
Yes.
Okay. And when we're talking about the 1,000 foot from a well, that's in the wellhead protected statute portion, correct?
Yes.
In Section A, if Section A says it's when you, for filling, for deleterious items you're putting back in, that was how, what applies with the wellhead protected statute.
Yeah, I'm not gonna testify as an expert on the county code.
Now, is it 1,000 feet from the property line, or is it 1,000 feet from the permitted area?
I don't think it's either. I think it's 1,000 feet from the borrow pit, because it would be permitting beyond that.
Okay, and, one moment. And as you here today, can you tell us where you did the 1,000 foot from? Was it from the property line or from the borough pit?
It would have been from the borrow pit. Anyone I checked would have been from where the contours start, not.
Nothing further.
Mr. Bates, you have anything else?
I was gonna have, Mr. Patterson testify briefly. I'm sorry, Mr. Connors, I apologize, I've got Patterson on the mind. Mr. Connors, who is my client representative.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and address, please.
James Connors, 925 Shawn Road, Molino, Florida.
Could we turn to Exhibit 4, 3?
All right, we haven't accepted 3 in. Board, do you?
Mr. Connors, do you recognize that parcel?
Yes, sir.
What is it?
It's a illustration of the front of my house, my fence, and my well house, which is right next to the fence.
Is that an accurate description?
Yes, sir.
Is it accurate as of today?
Yes, sir.
It was accurate as of the time the picture was taken?
Yes, sir.
I'll offer Exhibit 3.
Depicting exactly what? Mr. Connors' home and?
How close his well is to the fence, which is the border between his property and the neighboring property where the pit is going to go.
Right behind that bush is my wellhead on the right side. Yes, sir, right there. It's approximately 4 feet from the property line.
Do I hear a motion?
Motion. Second.
We have a motion and a second. All in favor of accepting this exhibit, please raise your right hand.
Exhibit 3.
Exhibit 3. What did I say? 4? Oh, I'm sorry. All right.
All right, and I'd also like to turn to Exhibit 2. Mr. Connors, do you recognize that document?
Yes, sir.
Did you prepare it?
I added to it.
All right, well, tell me what you took and what you added.
Basically, I took the footprint of the proposed dirt pit and I put in the location of my house and my wellhead and the location of multiple neighbors around the perimeter of the proposed site.
On this particular depiction, where is your home and well?
Bottom right-hand corner highlighted in yellow.
Okay, and to the, towards the top of the page, right under the north, south, east, and west indicator, it says Kite Dorch. What is that?
That's the illustration of the location of Mrs. Kite's house and Mrs. Dorch's house.
Did you compile the information in this chart in handwriting?
Yes, sir.
The handwriting is yours.
Yes, sir.
Did you independently do the research necessary to complete that?
Yes, sir.
I move admission of Exhibit 2.
We have a,
The only objection I have, relative to it is, from a wellhead perspective, it's our position that the wellhead is irrelevant, and noting evidence of a wellhead is confusing and improper because we already have evidence that the wellhead references potable public water.
Mr. Godwin, I suggest the statute says otherwise. It will argue otherwise, it will submit otherwise, and for purposes of the record, I want to establish where my client's well, W-E-L-L, is. Like I've said before, their conclusion that the county has previously approved their definition is not correct. In fact, Mr. Jones' letter does not cite the provision which we are referring to, and so it could not have ruled that way. And I am establishing the location of my client's well for purposes of whatever subsequent action we may take, depending on the outcome of this hearing.
any discussion on this? Do I hear a motion on accepting it in for the value that it will give us?
Second.
Okay, all in favor, raise your right hand. Okay. We accept it in, and it'll be given the weight that we believe it deserves.
Thank you. Mr. Connors, when did you buy this property?
It was May of 2020.
In May of 2020, when you bought the property, was the well there?
Yes, sir.
Was Was the well functioning then?
Yes, sir.
If you would please flip back to Exhibit 3. The fence that's shown there on the right side of that photograph, is that your fence?
Yes, sir.
Where is it in relationship to the boundary between your property and the subject property?
It is 1 foot off the property line.
1 foot off in the sense of closer to yours?
Yes, sir.
Okay, so you own the fence and 1 foot inside that property line?
Yes, sir.
Okay. And on the Exhibit 4 that's in evidence already, is your wellhead, your well, which you've just described on the photograph previously, within 500 feet of where this pit is going to be?
Yes, sir. In actual, earlier testimony had it wrong. The applicant is offering a 50-foot buffer on the property line. My wellhead is 4 foot off the property line. That puts my wellhead 54 feet off the pit. Previously, I think they said 70 plus, but it's not. It's 54 feet.
54 feet
Yes, sir.
from where this pit is going to be relative to your well.
Yes, sir.
Are you familiar with Ms. Dortch's property?
Yes, sir.
And if you look at Exhibit 4, you will see that in the upper left-hand corner, indication of Ms. Dortch's well. Do you see that?
Yes, sir.
Is that an accurate depiction?
Yes, sir.
Do you know how far that well is from the proposed pit?
143 feet.
Are you aware of other wells in this particular area that are perhaps within 500 feet of the pit?
I believe, but I've seen a well right to the east, but I tried to talk to the residents, but I've never been able to talk to them, but there is a well there.
How about within 1,000 feet?
I would think there are many.
How do you know that?
I don't know that, but there's earlier testimony from other residents have attested to that.
Objection, speculation.
It's well, yours, objection is noted and.
Move to strike.
Accepted.
Mr. Talbot has moved to strike, which is his impression of what the board's prerogative might be. I don't want to tread on his motion.
What is your objection to striking it?
His objection is to it, and he wants it stricken. He doesn't want you all to be able to consider what Mr. Connors just said.
And Mr. Connors said?
Mr. Connors, what did you say?
Well,
If I objected to it, hold on just a second. If I objected to it sustained, he refused to stop and kept talking to add more information. They sustained the objection because he lacked a predicate and he was speculating. So therefore, it should not be.
Well, I'd like to understand. I couldn't hear what he said. It would be helpful to the board to understand what he said. I am entertaining your objection, and if you will allow me to do that, please. Yes, please.
So the conversation was about additional wells in the area.
I'm sorry.
If you wanted me to let you know what he was saying.
Yes, but could you speak up just a hair?
Oh, yes. So the question was, are you aware of other wells in this area? And he has seen them, and he said to the right, has he talked to the residents? And the question was, how does he know they're within 1,000 feet? And then that's the objections are coming up.
All right, thank you, ma'am.
You're welcome.
Board, you've heard this motion to strike. What is the pleasure of the board? What is the comments of the board? We've had a lot of this give and take, back and forth, over this hearing. This looks like a garden variety of the same thing. That's my thought on it, but I'd like to hear the board before
I think your thought is probably correct, and I'll make a motion
to
strike.
to strike. Do I hear a second? Do I hear a second?
Second.
We have a motion and a second to strike, which is unusual for us. We do not normally have that sort of thing arise. All those in favor of striking the last comment as extraneous and not relevant to the topic, then please raise your hand. Let the records show that that statement was stricken.
Mr. Connors, is when you bought the property, and up until the time of the last hearing before this group in 2022, did you use that well for drinking water?
Yes, sir.
Are you using it for drinking water now?
No, sir.
Why not?
At the conclusion of the last BOA meeting in April 2022, Mr. Patterson put a hog pen next to my house, right on the property line, 20 feet from my house, 4 feet from my wellhead. So I had to shut my well down over fear of E. coli contamination.
When you say shut it down, did you close it or just not use it?
I just shut off the lever and I'm not using it anymore out of caution.
That's all the questions I have.
Yes, sir. Ms. Connors, when you bought the house in 2022, is that right?
2020.
2020. Public water was connected to the house, wasn't it?
Yes.
And you still have public water. You've had public water connected to your house from the time you bought it till today, correct?
Yes, many residents do for hurricane preparations.
And and you've been using, prior to May of 22, you used public water in your house. Isn't that correct?
Actually, I was using my private water. I have an account with Molino Water. You're referring to a $20 charge per month. That's a maintenance hookup fee. You pay that whether you use water or not.
No, I'm talking about you using water prior to May of 2022. You used the public potable water system from up there where you live, correct?
The water I used basically was my private well. If I use Molino Water, I have to pay for water. So there's a base charge of $20 a month, and if you use more water, then you pay to buy their water. So in essence, if there's a hurricane and my power goes out, and my pump goes out, I can't use my water, but Molino Water keeps going. So that's the idea. It's a backup situation, backup supply. Well, it was until the hogs were introduced anyway.
All right, now, sir, when we talk about wells, the well in your property is your personal well, is that right?
Yes.
It's not a public well, is it?
No.
You would agree that your property, your well is not a public well, correct?
That's my understanding.
You would agree that the other wells that you said you heard about are not public wells run by a municipality, correct?
That's my understanding.
I think that's it, nothing further.
Mr. Godwin, Mr. Merrill asked me if he could clarify one question he thinks he got wrong and he doesn't want to leave here with.
All right, that'd be fine.
Mr. Merrill?
Am I excused?
Yes.
Yeah,
Thank you,
please.
gentlemen. I
Thank you.
appreciate your help. Listen
Thank you,
today.
sir. Yes, sir.
Thank you, Mr. Chairman. When I was up here earlier, I believe I stated about 25 homes within that 1,000 feet.
Yeah.
I was sitting here counting them when I was doing it. I didn't have a scale. That was incorrect. It's about 12 within that 1,000. I scaled them off over there. And I say about because there's some trailers there that I'm not sure if people are living in or not. So,
Okay.
I just wanted to clarify that. It wasn't intentional. I just miscounted when I was here thinking I was outside of that.
Thank you. We appreciate that, Mr. Merrill.
Mr. Godwin, other than an argument that I'd like to present, I'm concluded.
All right, sir. Before we get into that, I'm sure Ms. Talbot Scott will have an argument too. Could Ms. Day, could you come up and ask, I've got a question that's come up and I'd like maybe if you could help us. Or help me.
Yes, sir.
Based on your prior testimony, if I understand what you said, excluding the character of these wells that we've been discussing, public or private, that a well within 500 feet of this projected project could become contaminated. Was that my understanding of what you said to me?
So the answer is first yes. So with wells, a lot of it comes down to how much water is being pumped out of them.
Yes, sir.
So for example, on a typical single-family house that's rural, doesn't have any public water supply, when you sink your well, you have a setback of 75 feet for your septic tank. So you can have a septic tank within 75 feet of your potable well. If it's non-potable, you need to have 50 feet. So on an individual basis, and it's, I'm going to state right off the bat, I don't know what they're utilizing the wells for, and so how much is being pumped out of it. But on a potable well that's public, because it's serving a large number of people, the distance of 500 feet is used to provide protection if we don't have any other data for the 7-year or the 20-year time of travel.
But even in a private well, contamination could still occur. Is that right?
It's
possible.
It's possible. It depends on the amount of water they're pumping out and what the source of pollution is.
And you've heard the testimony that, and I've heard a couple of figures that I've heard 60 feet, I've heard 44 feet, or for the depth of this proposed project. Are you comfortable that at 60 feet or 40 feet going down that deep will not disturb the aquifer?
It certainly will expose it.
Well, that was my point. It could be exposed, and if there are contaminants in the groundwater above it or the water above it, then the aquifer itself becomes contaminated. Is that right?
It certainly could.
And this aquifer, if I understand your testimony and testimony from other people, runs, this whole area is honeycombed with springs and various, I won't say, I guess aquifers or underground waterways. Is that correct? This whole area that we're discussing generally, beyond the barrel pit.
I mean, even right here, I mean, there is a groundwater level throughout Escambia County. All of our drinking water comes from the sand and gravel aquifer.
Okay. And therefore, it is possible that a deep pit could create issues with the water.
It's possible. I mean, there is a lot of ways that you could get contamination. It could be through a pit that directly does it. You could have, diesel spills. We've had, rail spills that potentially threaten drinking water. So it's because we have typically few confining layers, and there are some. Contamination that hits the soil certainly can make it down and make it into areas that wells are bringing it back up.
And generally, if you know, and you may not, in the area that we're talking about, the pit and the surrounding area near it, Do you know if the water levels are fairly high under, that, it doesn't take very much to dig down and hit water?
I haven't walked the site, but, there are wetlands on site, and, wherever there's wetlands, you know that the groundwater is at least within a foot of the surface, 4 to 6 months out of the year.
So, excuse me, the groundwater table potentially is high in these areas also, right? If I understand what they say with springs and that sort of thing. Okay, thank you, Mr.
If I
Day.
can- Okay, if I can ask a couple questions off that?
All right, sir, go.
Sir, just so we're clear, who normally handles the regulation of the groundwater and whether you can go down and dig in that area? Is that the Board of Adjustments, or is that another government agency?
So, for the pit itself, there'll be 2 regulatory agencies, being the county through the DRC process. He would also have to get a permit from the Florida Department of Environmental Protection. And along the same ways with the wetlands themselves, that will be regulated by DEP and the Corps in terms of potential impacts to the wetlands.
So the impact to the wetlands, that's not something for the Board of Adjustments to consider, because you've got experts that handle that separately? Is that right?
Yeah, there's a permit process in which the project will be evaluated and, permit conditions put on whatever is authorized.
And when we're talking about digging, okay, by the regulations, you can go no steeper than 2 foot over and 1 foot down, right?
Correct.
So by the time you get to 20 feet down, you're at least, is it 40 foot over? 20 times 2 is 40. Am I right, or am I getting something wrong?
2 feet over, 1 foot down, yes, 40.
Yes. So it's not that, hey, right where you permit, you're going down to hit the aquifer. You have to go down gradually, no steeper than 2 to 1. Isn't that correct?
Right, well, there'll be an angle, yes.
Okay. So by the
Certainly-
time you get down further, you may be more than 500 feet away.
I don't want to speculate. There's projected plans. I don't know that, even with the projected plans that we're looking at, those aren't, they could be the plans that DRC sees, but those certainly aren't engineered sealed plans.
Okay. Thank you. Nothing further.
Thank you, sir.
All right, thank you.
All right, we've reached the point in time where we would sum up. Mr. Talbot, if you'd like to sum up, and then, of course, Mr. Dave, I'm sorry.
Bates.
Mr. Bates would be allowed to offer whatever his thoughts were.
Yes, sir. There's been a lot of testimony and evidence today, and I think it's very important that we stay focused. Even though some people can be emotional or so forth, we're focusing on what the Board of Adjustments looks at. First of all, the law is very clear, and the evidence is this is agricultural property, and under the building regulations or the county code, that agricultural, it is permitted in an agricultural property subject to the conditional use. In other words, if you're gonna do this, they want the ability to regulate it and know what's going on and make sure that we take actions to protect it. The issues of the wetlands, the issues of whether the aquifer, those issues belong to a different agency. Those belong to the DEP and so forth. Okay? Issues concerning how many trees, or what is the exact slope, or what type of dust suppression, those are issues which are going to be determined when and if this board gives a conditional or a permit. We have, again, specialists with the department here that handle those items. So even though there's been testimony to that, I would like for to make sure we stay focused just on the issues here, just on what we're focusing on. Now, along that line, there's been a lot of testimony concerning if somebody has a private well. Okay, when you're dealing with a well, under that 500-foot provision applies, okay, very specifically, it's outlined in the wellhead protection statute. And the wellhead protection statute, as I indicated, okay, deals with when you are excavating certain items and that you are basically putting back in other construction debris or other deleterious supplies. That does not apply here because he's put in water. He's going to fill it and make a lake, so you don't get to that regulation because there's not that threat of the toxicity involved. Instead, what we look at the 10 factors that were outlined in the regulations. And can it be appropriate with the surrounding area? Okay, we do have a surrounding area that one to the north has storing dirt on it. We do have, it was previously a disposal area. Okay, it's agriculture. We have trucks going up and down the interstate, the road there that are dump trucks. Okay, so it's not a residential community. All right. With all due respect, I know a lot of people here, they say that's their house. But when you're moving to an agricultural area on Highway 95A, you can't just say, no, not in my backyard anymore, okay? We're on a thorough highway. If you want those protections, then you need to move to a southern, okay? When you move to an agricultural area along an interstate, you accept some of the things that happen here. Okay, you accept the fact there's going to be truck transportation. Okay, there could be other commercial. You could have a Tom Thumb put up next to you, all right? Or the county buildings a mile up the road. These are natural issues when you're in agricultural or permitted area. We had the one gentleman says, look, I don't care, I'm a libertarian, he can do what he wants on his property. That's what my client purchased that property for. When he purchased it in 2020, he came to the county and said, can I do this? He wanted to build the property, dig the ditch, and put his forever home there. You can always ask, what if? Or what if he changes his mind? That's for the committee to determine. He's telling you what he wants, and that's what we have to look at. As far as public services, which is the second prong, he's not going to usurp any type of too many public services. He has a standard power that he's going to use for his home, and water from this county water that's going to be used as home up there as well. Then ingress and egress, it's been already provided information. All these factors, when you go through them, support my client being permitted to use this property. The board, the people that are tasked with this during this department have agreed. Okay, they support his position. Mr. Day just stood up here. He said he supported this application. Okay, if there was issues concerning the application, they would tell you. Okay, my client is a respectable businessman. Okay, he wants to operate this in a respectable manner. He's going to submit himself to the control of the county, and he wants to make this his forever home. Okay, he should be given that opportunity, and he should get his conditional use permit.
The Board of Adjustment is charged by the resolution of the County Board of Commissioners to do, among other things, have this hearing. And the Board of Adjustment, I would say, is a gatekeeper. I will read from the resolution of the County Commissioners that created this responsibility for the Board of Adjustment. The burden of proof in quasi-judicial hearings concerning zoning-related matters shall be in accordance with all applicable local, state, and federal law. However, notwithstanding, the burden of proof shall lie as follows. The initial burden is on the landowner to demonstrate that his petition or application for use of privately owned lands, that is rezoning, conditional use permit, variance, etc., complies with the reasonable procedural requirements of the ordinance, and that the proposal is consistent with the comprehensive plan. The comprehensive plan prohibits what they are applying to this board to have approved. The comprehensive plan, and I had these all in exhibits at one point in time, but it became a little tedious to do that. The comprehensive plan provides, and this is the 2030 variety, that this conduct would be absolutely prohibited then, and it is not consistent with it now. Nevertheless, and I am amazed at this particular point, the applicant would have you all punt, or I would rather say abdicate, to boards, commissions, or agencies later to protect the people standing behind me. In fact, this particular project is before you all because it is not just within 1,000 feet of a residence, although that would suffice for purposes of requiring that they come here. It is within 1,000 feet of several residences. It is further in front of you all pursuant to a rule that absolutely prohibits a private well, prohibits putting this pit within 500 feet of a private well. I could take you through this statute, the development code, and show you precisely that result. Every time I have started to do that, it sounds too legal. But the opinion Mr. Horace Jones put out regarding the staff or the department's construction of that rule, which is a portion of the application that is before you today, cites to a different provision than the one that says they are prohibited from doing this within 500 feet of a well. Now, I don't know what the Land Development Code once said, but as of 2022, when I cross-examined the staff, and as of today, they acknowledge that the word well, W-E-L-L, lowercase w, is simply not defined. Throughout the code, there are adjectives appended to the word well. Public well, drainage well, any number of different kinds of wells. But in the portion of the Land Development Code that talks about wells north of Barano Park Road, it says unequivocally, not within 500 feet of a well. Now, what else? So we have several residences within 1,000 feet. We have the well problem. Then we have the obligation to determine whether or not this plan is compatible with the permitted residential uses. And so the same size pit on the same size property that was not approved in 2021 and not approved in 2022 is here today in front of you once again because they say, well, we've added buffers. Well, all they've done is drawn a narrower line on the map. They haven't told us what those buffers are going to be, how efficacious they will be. How in the world are we going to determine whether or not this is consistent with lawful residential use for these people that are right on this property vicinity or within the 1,000-foot radius, and for that matter, the larger area of people in this particular area? So I would sum up by saying the evidence today is no different than it was 2 years ago and 3 years ago. In a court of law, the argument would be res judicata, thing decided. You wouldn't be able to come back. One of the witnesses asked you all, how often are we going to have to come back here? Does every change in the composition of this board give the applicant an opportunity to come back before you all and seek a different decision? Well, he's delayed 180 days and then he can go back again and we can spend all this money and all these people can come in once again And what are we to say about the res judicata effect of what this board does? How are we to rely on the decisions of the Board of Adjustment? I suggest that the evidence today is no better to sustain this application than it was 2 years ago or 3 years ago. And I submit that this board ought to feel compelled to deny this application, and respectfully request on behalf of my client and all the other people who are here today and who testified about they don't want this in their backyard, I respectfully request that you deny this application. Thank you.
Thank you, sir. I believe we've reached the point, board, where testimony now is closed, and it is time that we deliberate as to this matter. I'd like to hear what board comments there may be concerning this matter.
I find the compatibility issue just flagrant, that it is not compatible just for the fact that we had this many citizens show up to protest it. And that's where I will vote, Mr. Chairman.
Mr. Smith, I can't really hear you very well.
Oh, I'm sorry.
Yes, you're on. There we go.
I find that this project is not compatible with the citizens and neighborhood of that area.
And Marty, you have a comment?
Yes. I believe that there are only two issues that have been talked about in depth here that we should be considering. Certainly, traffic and wetlands issues are not under our preview. But I think that the situation with the wells and with compatibility and the distances surrounding the proposal, the numerous homes that are there, indicate that this proposal is not compatible with the surrounding area, and certainly doesn't meet the requirements of distances for residents and wells.
Ross, did you have comments? I find it troubling. Too, I would agree with my colleagues that compatibility is an issue. I would also believe that the staff erred in whether or not this would constitute a nuisance. Accepting the testimony of the expert that there are perhaps 12 homes that lie within this area that just seems to be an indicator of the province or the problem that we face with this application. And I spoke with Mr. Day specifically about the wells, excluding their character, whether it's public or private. And he, as I understood his testimony, was very clear to me that private or public, that with a project like this, that there is the potential that those wells will become contaminated. And my other concern was, while I accept that this will, and I have no reason to doubt the veracity of the applicant's statements that this is, will be a home in the coming future at some time. I have no reason to believe that he is not an honorable man and has given us testimony that is his belief. Unfortunately, we have to be cautious about these matters on the board. Escambia County has a long history of catfish ponds and that were going to be built from these borrow pits. And it's some years ago, you may remember in Cantonment, there was some of you who were here, if my memory serves me right, there was such a pledge, and it, to my knowledge, never really was fulfilled, and it created much unhappiness in the neighborhoods. So while I always try to believe everyone when they present their testimony, we just, as a board, have to be cautious in these matters. And this area is growing, and I worry myself about the agricultural character of the northern part of our county is being lost because people, as one witness said, there's no place down here to build, it seems. Everyone is moving north. And that's true. So this is just not a, given the location and the geography and the, it just doesn't seem to be a suitable project. Now, maybe 20 years ago, that would have been an entirely different situation, but not now. And so I personally can't support it. Ross, did you have anything else? Did you have anything before we call for the vote?
And Board, your staff's recommended approval, so if there is a motion to deny the conditional use, then please address the criteria and the code.
Yeah, can we go back to the criteria? Do we have a motion? If we can get a motion, then we would go to the criteria and identify. I have a motion to deny this application and to overturn the findings as it relates to this matter from the staff. Do I have a second?
Second.
Can you identify the criteria?
Yeah, we are going to, if it's overturned, we will. We'll identify exactly how it's.
I think maybe to clarify, Mr. Chairman, if you could make it part of the motion, which specific criteria you're disagreeing with?
Okay. Are we, okay, we're there. Who made the motion? Was it Marty? Marty? Yeah. A is compatibility. I know we discussed that one.
Criteria A and
D.
keep going. Must be the last one. Where, I don't remember which criteria it was, the 1,000 feet.
Not a criteria.
F.
Yes.
Sorry.
And if we might go back up, I would like for maybe the board to consider nuisances and hazards, all that one.
I would agree to that modification of my motion. Criteria D be included.
So you've identified A and D, is that correct?
A and D, so.
And if you could go down one more here. Let's see.
I is the item that has the other code requirements.
I wonder about, go back up, please, just a little bit. And then down. Oh, let's see. The buffering, I'm not convinced that, we've had testimony about whether or not there would be sufficient buffering for this project. And I'm not certain in my mind that there is adequate buffering to protect against, well, the site and the noise and that sort of thing.
I agree. I don't believe there could be any amount of buffering that would stop the dust. I live two or 3 miles from a borrow pit, and as good as they take care of it, it raises dust. That's one of the reasons why I don't believe this is compatible with the area, because it's residential around it.
All right, board members, we have identified the areas of disagreement with the staff. And is there any more comments the board wishes to make?
If we could, I'm sorry, Mr. Chairman.
Yeah.
I'm looking at my notes here. I've got A, D, F, and I. If that is correct, I'd appreciate if you could put that into your. Okay, thank you.
Thank you, Andrew, for keeping us on track. Are there any more comments? Hearing none. There is a motion now to disapprove this application and also the identified staff findings of fact. I'll ask now that everyone that is in favor of this motion to please raise your right hand. Let the record reflect that this application was denied by a vote of 3-1, and the matter is closed.
Sir, before I want to put on the record, member of the board just stated that he doesn't think there could be any buffering, and he based that on his living 2 to 3 miles from another pit, and that there's no way you could do to have that buffering. On that basis, he should have recused himself and not participated in this because he's previously biased.
If that's a motion, I deny it. I deny that. That's not germane to where we are. Is there any other business relating to this matter? Okay, I thank everyone. I especially thank all the many people that came. I'm sorry they went home early, but this is a long and laborious project, and so, but we do appreciate your participation. I appreciate council's arguments, and I know that sometimes we get spirited, so everyone, I think, found it very illuminating.
And
thank you.
Mr. Chairman, the next meeting is September 18th.
All right. Here, let's let the crowd.
Okay. Yes, sir.
Next is September 18, and how many cases?
I just have one. The meeting last month where we didn't have an agent show up.
Yeah.
Oh, they're showing up this time.
All right, well, looks like the meeting's adjourned itself. I'm sorry, I can't. Yeah, I just adjourned.
So I didn't hear it because everyone started talking around
Yeah.
it, but I wanted to make sure that I ended it.